I want to welcome everybody. Just here in Nashville. Hope everybody had safe travel in. I know that we have a couple of guests. One of them seems to have popped out, but at this point, I'm gonna turn this over to Wendy and let her tell us about somebody that's new that will be working with us.
Great, thank you, Mr. Chairman. I'm going to introduce you all to our new staff attorney. So at the last meeting, Sveta was with us. She was our staff attorney, and she's left the department. So we are welcoming Neil Stauffer.
This meeting is being transcribed.
We are welcoming.
This meeting is being recorded.
We are welcoming Neil Stauffer to the legal team. He'll be our attorney. And I'm just, Laura created an introduction for me. So I'm going to give you a little bit of his background. He joined the department on April 24th, so last week. He began his legal career as an officer in the U.S. Army Judge Advocate General Corps, JAG, where he served on active duty for 8 years in a variety of criminal and administrative legal positions. Neil's active duty career included assignments at Fort Bragg and Fort Campbell. Neil deployed twice overseas in support of Operation Iraqi Freedom and Operation New Dawn. Neil continues to serve as a judge advocate in the U.S. Army Reserve. After leaving active duty, Neil served as Assistant General Counsel with the Tennessee Department of Health, where he litigated cases involving nurses accused of violating standards of practice pertaining to patient care. Neil later served as Assistant City Attorney for the City of Clarksville, Tennessee, where he handled civil litigation and provided legal counsel regarding a variety of municipal issues and administrative matters. Neil and his wife Tiffany live in Clarksville and have 3 children. Neil received his law degree from Regent University School of Law in 2008. And tomorrow we can leave some time for him to say some additional things about himself, but welcome to Neil.
This is Neil.
This is Neil.
So
Good timing.
we're very honored to have you working with us, Neil.
Also, Mr. Chairman, also next to me is Laura Martin. She is Chief Counsel. So you all are familiar with Tony Glandorf, who recently left the position of General Counsel. Laura took his place as Chief Counsel. Did I say that right?
Yes.
And she has been with the department for a number of years and was a board attorney at one time, and then served in a policy role before coming back as Chief Counsel.
Glad to have you with us today, Laura. Thank you for being here. Since we have some new faces, we normally come in on the day before we have our quarterly meeting. At that point, we go through committees, and today we'll have the licensing, the laws and rules, enforcement, and executive committees. In the past, we've been very successful on having the committee meetings. Thus, we were able to go through things faster tomorrow. This gives us an opportunity to have more discussion and to kind of vent and talk about the different issues that the committee may bring and ask questions. And so we openly are excited about that, and we use this time to kind of go back and forth and ask questions before the committee brings it to us tomorrow. With everybody driving in, it always works out good that we use this day to kind of prepare for tomorrow. So with that, I'm going to turn it over to licensing, and we have Pamela Church, who's the chair of that committee. And Pamela, welcome. And for those who don't know Pamela with our new faces, she's a professor at the accounting side, and she's very knowledgeable, and she does a great job, and she's got a lot of history with the board. So Pamela.
We only have one petition today. It's from Rami Shukri Nasif, and Rami is requesting an extension on the FAR part of the exam. Rami passed that in November of 2021, and it will expire May 11th of this year, 2023, without an extension. Rami was on family medical leave for 63 days outside of the country in Egypt, 5/20/22 to 7/20/22, so pretty much right in the middle of this. and states unable to study and sit for the exam as I was in Egypt, providing care for my sick mother. I would like to request an extension for those 63 days if possible. And attached is medical documentation, doctor's certificate, and airline tickets. So we do have appropriate documentation. I would move that we grant the extension. 63 days, according to my count, is July 13th. So I was thinking maybe July 31st. But open for discussion.
Motion's been entered by the committee, and at this point, I'm going to let Pamela, each committee kind of does their own thing and then votes. And so I'll ask if there's any other committee members that want to vote or second that.
I'll second.
Session. I'll let Karen call the roll.
Tom Church.
Aye.
Janet Booker Davis.
Aye.
John Griesbeck.
Aye.
Gay Moon. Aye. Rob Vance.
Aye.
All right, anything further? I think that's the only thing that we have in front of that committee. Thank you, Chairman Church. Appreciate it. Our next committee is Law and Rules, and just a background, we've got the chair being Larry Elmore, and this time Larry's been heavily involved in the UAA model rules. I believe you've been on that committee for 2 or 3 years. On 3. As everybody knows, the accounting profession, specifically CPA profession, has had a lot of changes. We are one of the few professions that has the ability to have mobility across the United States. I think you'll see that a lot of nations around the world are coming here and asking NASBA, how did y'all pull this together? So NASBA and AICPA are actually going out and sharing what they have done and how they put it together, and a lot of other professions are trying to model after us. And you know, and you're only as good as you are today. And there's been a lot of changes on the UAA side, from questions about pipeline and questions about, you know, COVID and what it did to every profession. I don't think there's one profession that has never had anything said about it that they don't say we don't have enough people in our profession right now. One of the more interesting things that we heard at the board meeting that we had at NASBA was that Ireland CPAs had actually come to them and said, hey, what are y'all doing to get students? We can't get students in school. And so it seems to be a problem worldwide. With that, the UAA committee has been extremely involved in the changing of the exam and different rules. And in fact, our own Larry Elmore, and I was going to say this yesterday or tomorrow, but I think I'll say it today, he was instrumental in actually at the meeting talking about, hey, we need something in between. And he pretty much pegged what not only the UAA committee talked about, but also what the board voted on. And so he has a huge influence on that committee, and he's represented us well here in Tennessee. So I'll turn it over to Larry.
Well, Andy's given me a whole lot more credit there than what I deserve, for sure. Let me say, first of all, we've got a lot of new faces here, so I'm sure your first thought is, what in the world is wrong with that guy's voice? So I'm recovering from throat cancer, and the radiation treatments did a number on my vocal cords. And if you'd seen me a year ago, I've come a long way from what I was. But anyway, I sound like a ratchety old man anyway still. But anyway, it's good to see all of our new help, because we need all the help we can get. Let me say a few words first about what the UAA is for some of the new folks. The UAA stands for the Uniform Accountancy Act, and so it's the model rules that all states use to come up with the individual state rules. So, for example, in the case of all these that we're going to talk about today, all these changes, each state can take these suggestions and the model. It's kind of like a template, so to speak, for states to use going forward on what they want to do with their rules. So in our case, these are our reaction, come out with the suggested model. So I'm going to give you the 30,000 foot level, and then I'm going to turn it over to Wendy to talk about the specifics that she and her staff worked with to come up with this presentation today. We're basically taking the time window that we give I try to say students, but it's not always students, persons taking the exam, applicants for licensing, to pass all 4 sections of the exam. So it used to be up until this presentation now, they had 18 months, a window of 18 months from the first section they passed until they could pass all 4 sections and still keep the ones they passed. The theory there is you don't want to give people just infinity to pass all the sections, because if you pass one section several years ago and don't take the rest until later, you're not uniform in your knowledge of the various sections. And the exam is getting ready to change big time anyway. So the committee, when we met, there were several factions of the committee that wanted different things. This first window of time was put out for comment, and I think there were 900 and something comments on the question of how long should we give. Now, in fairness, I think something like 300 of those were students still in school maybe, or close to being out, who would be the prime candidates who would be taking the exam mostly. And then there were faculty, and there were individual practitioners. There was a category of firms, and then there was a category of state boards and state societies. And so you had a wide range of people, but the vast majority of those responses, if you take the full gamut of people who responded, it was far in favor of 36 months as opposed to the 18 that we had previously have now. So the committee, what should the time window get a recommendation now in that meeting? So the options that were given were 24 or 36 months, which either way would have been either 6 months or a year and a half more than the board, sort of a compromise, which adds one. So the major changes in this first rule are going from 18 months to 30 months, and then moving the date that the clock starts from the date you use the date the passing score is released by NASBA to the candidate, and then the concluding date the candidate sits for the final section. Notice that says sits, not passes. So if it's the passing score that you got, you did pass, but the date that's used is the date you actually sat. That's you have on the next page the copy of the old rule, so you can look at. There's a couple of things that were deleted from the old rule, but as far as additions to the rule, that's the change for the most part.
Sure. Thanks, Larry. A couple of things to note. The prior wording still had some references to the windows that we used to be under, where we would have testing available in the first 2 months of a quarter and then a dark month in the third month. So that's kind of how why the numbering is different than it was before, because we did delete some of that language. So as Larry said, the three main things here are the time period starts when the score is released rather than when the candidate sits. So the current rule that your time frame starts at the day you sit, and we are changing that to the date the score is released. That's going to give candidates some additional time on the front end. Right now, score releases are anywhere from 2 to 4 weeks from when someone sits, but as the new exam is launched in 2024, score releases could be delays up to 4 months. So folks are going to have to wait on their scores. So this will help them in that situation. The second thing is, of course, we're proposing going from 18 months to 30 months, for which they have to pass all test sections. Currently, there's 4 test sections. And then the final item to just pay specific attention to is in your first page there under E. There are now reasons by which the board would extend that 30-month period. So in the previous wording, it simply said that the board, in particular cases, could extend the conditional credit upon showing the credit was lost for reason of circumstances beyond the candidate's control. And the new wording, this actually gives some specifics as to what might be included in those reasons. By reason of individual hardship, including but not limited to health, military service, disruption of local, regional, or national level impacting the candidate, or other circumstances beyond the candidate's control. So it doesn't limit your authority, but it does give some more specifics as to what might qualify to extend someone's score beyond the 30 months. So those are the three main things for this rule. I have 2 other rules that I want to talk about. So before we move on to the next one, does anyone have any questions about this?
I have a question about, I want to make sure I understand. So it seems like it was so long ago, so I cannot remember. But when you were still finishing school, if you were like in your last semester, you could test.
Correct.
Okay, can you not do that anymore? I had a UTC student ask me that. He graduates on December 16th, and there's a test on December 15th or something. He doesn't think he can take the test.
So you do have to have a bachelor's degree conferred in order to sit. So you don't have to have your 150 hours.
Okay.
But you have to have a bachelor's degree. Okay. And so I've had an inquiry from one of the professors, maybe the dean there.
At UTC, okay.
Right. And she is concerned about first-time testers wanting to sit for BEC.
That's what.
And December 15th is the last day. And
they can.
Huh?
They can or they cannot.
Well, if they don't have their bachelor's degree conferred yet, they wouldn't be able to sit.
But if they're just working on their 150 hours, I mean the additional hours.
Right. If they already have their bachelor's degree conferred, then they could sit. But the way she explained,
appropriate accounting.
I'm sorry.
With the appropriate accounting hours.
Right. You're correct.
Okay.
Yeah, you would have to have your 18 hours of upper division accounting as well.
All right.
And so I think what she was bringing up is that some of these candidates won't have the requirements met until maybe December 16th.
Which is one day.
But these are first-time applicants. So, it just so happens that this year is going to be different because testing stops on December 15th for the transition to the new exam.
So it throws them into a whole new...
It'll just it'll throw them into having... But these are first-time. They have never sat before. Yeah. I suggested she just have them focus on the new exam, but
okay.
Other than that, she didn't have any reason why this was problematic.
Yeah. Well, I know that the student that I spoke with, they, as a class, they talked about all these workarounds they could do, something in Alaska and then transfer and all that. I just didn't want, I mean, I just remembered back in the day, you could sit as you were finishing school for the exam. And I mean, what 150 required at that point, you know.
Right. And they're still able to sit before they're 150, but they have to have that bachelor's degree and the accounting hours.
Okay.
I think when we moved to the bachelor's degree, it was the previous rule was that, or previous law was that you had to finish your education within 200 days of sitting. So
Yeah.
it was, I don't know how
That
many
sounds
months
right.
that works out to be, but that was the prior law. And then when we changed it, it became specific that you needed to have that bachelor's degree conferred and the appropriate education. So it threw people off. But I just think as we transition with the exam, that they likely should just focus on the new sections.
And that's what
Yeah.
I mean, I said, I don't know. I'm going to ask questions because I know we're going over this particular stuff.
Does that make sense, what I'm saying?
Yes. It makes sense to what I remembered from back in
Yeah.
the day, and now it's new. And then I don't know. I just that one
Said
day
that they would
thing
have until
just-
December 15th, and their degrees are conferred December 16th.
Yes.
They would, when they apply, does the degree have to have been conferred, or it just has to be coming in before their sit date?
Right. So the way it reads is that you can apply in advance of receiving the education, but if you sit before it's actually conferred, then those credits are no good. I mean,
Don't the days to sit cut off December 15th?
this year testing stops on
I know
December 15th.
it was starting early. Yeah, because I mean, I was wondering seriously if their registrar's office could do something to get the degrees conferred by the
it
15th.
seems to me that
Well, they'd have to be
those
conferred
people that
before
wanted to,
I don't know.
Yeah.
That's cutting it real close.
I mean, it's cutting it very close.
close.
It means they're going to have to secure a date on the 15th to sit
Yeah.
in the location that they choose, and then have that transcript state December 14th or before that they conferred.
okay.
I just think it's cutting it close to be relying on that. But your option of going to Alaska and getting approved under that jurisdiction and then transferring back, I mean, all of that can happen, but it's a lot. And it ends up costing the candidate more because when they transfer the scores back here, we have to send them back through an education evaluation because the education in that state may be different, and that they incur more costs there and time having to have everything resubmitted. I don't know. It's an option.
I
But
agree, and I'm like Pamela. It just seems to me like if they want to go ahead and do it, maybe they can work out something with their school to.
And I've certainly had students who did those types of things.
Okay.
Who, before we allowed people to sit, I guess, during their master's while they were getting their 150, I think, I don't know. But I've known people who went through Alaska and New York and various ones. Becker advised them to do that. I mean, there's nothing really wrong with it, and Tennessee has been very generous and lenient, I think, in having, dealing with those sorts of cases. But,
I have a question, or maybe this is Pam. What does it mean to have a degree conferred? What is it? Is it the stamp of approval? Is it the graduation? What is it? What does this mean?
It's the
Does
day
anyone
it
know?
hits your transcript, so it probably is the day of graduation.
It's graduation,
I'm thinking. Yes,
I think is what that class was interpreting it to be.
So it may not be able to be moved. I don't know the legality of it, but the way I see it, Judy, is that the policy now is actually more generous than when you're referring to, because they're pretty far removed from the final, achieving the final requirements, which are 150 hours. The ones you're talking about, they were almost finished. When the rule was that you could sit your last semester basically within certain so many days of getting the final total requirements fulfilled.
Well, that is the
This is-
case in this situation.
Isn't there no,
graduates-
it's a baccalaureate though.
No, this particular student completes his education on the 16th,
Baccalaureate or 150.
150, everything.
Well, then he can sit.
And he could,
Okay. Well, I'll let
It's
him know that.
it's
That's where he was
baccalaureate,
confused.
including 18 upper division
Okay.
accounting.
I'm gonna make a note.
I mean,
I'm just making a note.
assuming
so.
that he has a bachelor's degree
And anything.
and in anything,
Okay.
and the 18 hours of upper division. And that's another thing that I have learned recently. Our requirement to have 18 hours of upper division accounting is actually, I think, the lowest in the country to sit. So what happens is these other states allow you to sit before getting your 150, but you still have to have the same number of accounting hours as you do for licensure. And so allowing folks to sit at only 18 hours of upper division, we are the most really lenient state when it comes to allowing folks to sit from an accounting hour standpoint.
Okay. I will reach back out to this. But I wanted to also, just because we're talking about this young man told me that he's doing a couple of different internships as well. And he's run into over a handful of people that have changed their major at UTC to accounting because of this one professor there that had, and I cannot recall her name, but I can find out. But it just sounds like she has been very instrumental into driving students into the accounting pipeline from management, finance, marketing, all of those different business. She gets them in principles 1 and 2, and she believes in them and just really makes sure they get the concepts, and then they're like, oh, well, I could do this, and the positive encouragement is there. And I don't know how many things we've done with UTC, but it just sounds like might be good to set something up if we haven't and get involved with that particular professor. Sounds like she's doing a lot to
Maybe
help
it's the same one that reached out to me. She's
What's
the
her name?
dean. I think her name's Rebecca.
No, that's not her.
Okay.
Okay.
Becca Short.
I'd have to look it up.
What's her last name? Okay. I don't think so. Amy, I think it. Anyway, I'll find out. I'll get back with y'all.
Okay.
Our professor told me his last name and learn how to pronounce it. I was like, really?
How do you think
But
we survived?
I would definitely need Google to pronounce this one.
So I didn't want to take us down a rabbit trail. I just want to. I'm not so sure that our upcoming candidates for the exam completely understand everything, and and I think they're all trying to get a grasp, and maybe it was a project for the class to try to learn these different things. So
I just finished looking that up and running it off for a class I teach that's half finance seniors and half accounting seniors, because I think even if the accounting people are hearing it, other majors may not be, and possibly they'd want to retool and come into the CPA profession. But it's quite easy to find on the board's website, and it's, if you didn't know what you're looking for, you might not understand if you didn't read carefully, because it's requirements to sit, but exam requirements and then licensing requirements, and so they do have to be aware of that.
Wendy, one question with respect to the UAA modifications that we've discussed so far. I think based on earlier discussions, some of these will require a formal regulatory change to be initiated by the board. Is that the case?
Yeah, so That's what we're basically doing at this meeting, is hoping to have you all approve the wording of the new rule, and then we'll start the rulemaking process, which will then have us go through that process and have a rulemaking hearing in hopes that then we would have a rule effective sometime early next year. So if you approve it today, we can start that process. If some of the wording is not where we want it to be and we need to redraft, then that would be at the next meeting.
We need to address these separately.
Well, I would like it to be all in one rule package, but I wanted to focus on this change before we went to the other two, just to see if anyone had questions. Really, my last concern with this is implementation of it. I would ideally like this to be effective sometime during the dead period, December 15th through, I think it's January 10th when they start testing on the new exam. Now, we can't typically, in our rulemaking process, we can't control the effective date. We approve it today, we go through rulemaking hearing. Once it gets approved by the Attorney General's office, it gets stamped, and then it's effective 90 days after that. So we have a difficult time setting an effective date. You know, and they really guard against us putting an effective date in the rule, like saying effective January 1, you know, this is how it's going to be. We are still waiting on, quote, an implementation suggestion from NASBA on how this would look. So I guess my only question particularly, or for maybe legal counsel, is how do you feel about putting an effective date in the rules? Should we not do that? Is there any other way to manage how to get an effective date when we want it to be effective?
And I would add that, Wendy, I think the dilemma is this. Let's say that somebody's section runs out in July, and then we've changed this rule, and have we implied the fact that now that's going to be backdated, so now that would have another year, plus now it would go past January 1st, so they get the extra extension.
So before we let Laura comment, I've had some further discussions about that, and I think that that will be a separate case for the board to consider at some point. If you've lost your credit before this new rule were to go into place, the board will have to decide under the extension policy whether you want to reinstate any credits that have already expired. If this is implemented or effective and there's anybody in the pipeline who has an active score, will then be redated accordingly. But if your scores have expired already when this is effective, we'll have to address that separately.
But that's so complex because if someone's score expires this July and then they say, okay, it expired, let's say it's BEC, then they may start taking something else, and they may act accordingly.
Yes.
They may act accordingly and start taking parts, and it doesn't, I mean, I'm not trying to use legal lingo. It doesn't make them whole. It doesn't take them back to where they would have been if we could start this policy, say now. That doesn't have the same effect as it will if in January we say, okay, anyone who lost it, here it is back. Meanwhile, they may have already taken another part, taken it again, studied, taken it again, etc. You know what I'm saying?
That was the purpose of making that statement, is this thing has so many webs on it. It would be great if legal could tell us that we need an effective date as of tomorrow when we pass it to go through the process. Because it would, in other words, I think it could hurt Tennessee students and then our stakeholders, because it would say they may get to the point that says, oh, I've lost this, so then now it's costing them more money, it's costing more times to take the exam, where they could go ahead and sit for that other part immediately on premise that this was going to pass.
And I
That's
think
kinda
we're
how
going to start
but
seeing.
I may simplify it in the way I said it, and I don't mean to because it is very much a mushy subject.
I think we're going to start seeing people requesting extensions using this as reasoning. And that's going to be really tough to say, no, we're being strict now, but just wait. Or, I don't know. There could be negative repercussions.
I kind of want to. Hi. Sorry. I want to say there's a couple options here. One, we can put language in there for an effective date and leave that sort of vague at the moment. Because Wendy's right. There are a ton of steps for the rulemaking process. I know you guys are familiar with that. I'm sure you also know that we don't control all of them 100%. It takes time. That is by design. But at the rulemaking hearing, which will have to be conducted, is the sort of the last opportunity for the board to make any edits. So we could always maybe come back at that date and say, okay, the language has been in here. We need to edit whatever date we've put in here. Reflect sort of the practical implementation of the rules, considering where we're at this point. Secondly, even the way that this rule is drafted, Wendy talked about you're still given a ton of wiggle room, right, to give people extensions or not. So I would encourage you, when you do find these people that maybe fell into the cracks, like those would certainly you can just take those by case by case basis, and then decide how you as a board want to interpret this. My assumption, so you can correct me if I'm wrong, is if we're implementing this, which seems to be, intending to offer more flexibility, is like you said, it would seem a little odd. It would seem like our policies are going from being really stringent to a little bit more flexible. So I would encourage you to think about that. But you would have even once it's effective, you would have to allow you to look at each candidate that, like you said, and both of you have mentioned, fall into these weird, intersections, and sort of on a case-by-case basis determine what the best thing to do for that candidate is. Does that answer some of your concerns?
Ask another question. How does this interact with that blanket extension under the new exam once a new exam is in place?
So as a reminder to the board, in July of last year, based on a recommendation from NASBA, the board approved an extension policy related to the launch of the new exam, so that by which any individual that has active credit on January 1st of 2024 will receive an extension until June 30 of 2025. The reason for that was the significant score release delays that'll occur over that time period. So in essence, Pam, anyone who sat for and passed the exam July 1st of 22, that 18 months back from or after, will have credit on January 1st of 2024, and we'll get that additional 18 months. So again, anyone who sat July 1st of 2022 will have credit on January 1st of 24, and will get an additional 18 months. So the problematic period is the folks that have credit expiring really all during 2023, and I have to go back to figure out in my mind how far back you'd have to go to figure out.
Because if we could implement the 30-month
time period
immediately, some of those people would not only get that through the end of this year, that they'd go 2 more years.
I think what we're looking at today is the rule change. And I agree with you that there's more to decide here. I don't think we're ready to make that decision yet. hopefully by the next meeting, we'll be ready to make that decision. But at least we can get this moving.
I think you'll be bombarded with
Yeah.
requests for extension before then.
Yeah. Yeah, I've already got a handful for the next meeting. And so that's why, we do need to have an answer, hopefully by the next meeting, of how we want to handle this.
But I see no reason we would not pass this unless there's another way to word it to make it a little bit
I think
more
if,
straightforward.
what I'm hearing Laura say is if we approve the language today, but we need to add in a date of some kind at the rulemaking hearing, we would be free to do that without shortening the process.
Right. I think you can have potential edits. The rulemaking hearing is the last time to make any potential edits.
And about when is about how long before the rulemaking? I know that's not carved in stone.
A couple of months at least, 6 months.
So is there any feasibility at all we could have it by July? That's 3 months. Wait.
The rulemaking hearing?
Yeah. No. So
Sorry. Just no.
So likely we won't get a rulemaking hearing until our October meeting. Now,
I want to remind you though, and I should have said this the first time. So yes, you can make edits at the rulemaking hearing. At that time, if you make really substantive edits, you do have to sort of like go back and like it will have to go back to the Attorney General's office and all of that. But we can do that if that's something you want to do. I will say though, when I look at E in the proposed rules and then in the currently effective rules, I think it's in C.
Mm-hmm.
I mean, you are able to, you have a lot of discretion here about how you want to handle it. So I don't know that it needs to be an effective date in the rule. All of these on a case-by-case basis, and then decide how you want to do them, or you delegate some of that to Wendy and say, okay, anybody that comes in that exceeds 3 years that their time, then we want to hear about that case specifically. But anybody, within that window, you can go ahead, and we're going to say that there are lots of different options for how you can deal with this. And I don't know that you need an effective date, but we certainly could put an effective date later down the line if that was absolutely necessary.
We put an effective date in here, and the effective date were to be taken out. Would that delay us? Would that be considered a major change that would have to go back?
It doesn't. It's not as if you start back at square one. Let me think through what I'm saying. General's office reviews all of our rules, usually prior to the rulemaking hearing, to ensure that they are constitutional, that we're well within our authority, and all of that. So anytime we make substantive changes after that, like at the rulemaking hearing, we do send it back to the AG's office for them to review again. But it's not as if you're starting the process from square one. I'm just saying that if you wanted to have an effective date, we could add the language and then maybe edit it closer to that date if the date that we put in now is not practical. But also just hearing Wendy talk about, some of these other provisions, I also think that you could probably accomplish what you want to accomplish without that. These are your options. That's what I'm trying to present to you. Those are some of the ways that you could go forward.
No. I mean, my recommendation is to consider the language we have today, and then with a plan that by the July meeting, we will have much better information on how to handle the people in the gap that we need to handle. And be able to talk through it, think through it. If you asked me what the effective date should be today, I mean, I initially said January 1st of next year, but is that truly the right effective date? Should it be December 15th? Should it be the beginning of this year? Should it be the beginning of 23? I mean, it's hard to tell what effective date you would give if you asked me or pinpointed what you wanted me to do, what we wanted to approve. And I think, as Laura said, that section gives us pretty broad authority to kind of lump in the group that we feel might be disadvantaged.
Wendy, has there been any guidance put out by NASBA regarding this, or Larry, or if not, would you expect it to happen? I mean, how many state boards are there? Everyone's going to be going through this.
This was, just approved a week ago, and we're really, I think, one of the first boards to meet. I could have put it off till July, but was worried that would delay us even more. Pam and I are on the Computer-Based Testing Administration Committee. We meet May 18th, and we're meeting in person. And the primary objective of that meeting is to get some framework around this and some implementation. So that's why I feel good about we'd have some better information by July.
So, as chairman of the Rules Committee, I'd like to make a motion that we approve this change, and I would entertain a second.
Second.
Okay, we have a motion and a second. Any further discussion?
Larry, I would just like to say I was at the office last week, and I had several staff come up, and they were pumped about this change. So, and their other question was, all right, when's it going to be effective? But I think it's going to be a real help to our young staff and accounting majors.
So we have a motion and a second. No further discussion. We'll go to a roll call vote. Aye.
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 Dee Weatherby,
Aye.
Janet Booker Davis,
Aye.
So the second rule that we're talking about today on page 3 of your handout there relates to something we discussed last meeting, where we had a candidate who was asking for reinstatement of their grades from passing scores from more than 10 years ago. And so, if you recall, we talked about this specific case, and we talked about the fact that similar cases had been approved in the past. And so the more we talked about it, we decided, well, why do we even have this rule that we presently have where scores expire 10 years after the first passing grade is earned? So we said, well, if we historically have approved requests to have them reinstated, then let's look at what it would take to change the rule. There was some discussion about remove the rule versus change the rule, but we really think it's best at this point to change the rule and just keep some guidance in place for these cases. But I think we all agreed last meeting that it would be good to have some guidelines for further requests, where the new rule would require 80 hours of continuing education in the technical field of study. And as you can read here, of the 80 hours, at least 2 would be Tennessee-specific ethics. And definition of the qualifying CPE would be found in the rules. So, say more about that, or?
I will add that the model rules do not speak to expiration of exam scores. So there are a good number of states that have no expiration date to exam scores. Then there's another grouping of states that are all over the place because there are no model rules. So there are folks that expire at 3 years, at 5 years, at 10 years, or you have to get CPE like this rule suggests, or you have to get your experience within so long of a period of time, or you have to finish your education in a certain period of time. So it was really all over the place as to what states do. So this is my attempt at a rule based on what you as a board, the decisions you all have made over the past couple of years related to this. So we have approved, the board has approved any extension request that's come before them in the past several years, but you have tacked on continuing education as a requirement to licensure. So this rule change attempts to fit that into rules so that we don't have to have that come before you, but it's an automatic provision if your scores are more than 10 years old.
I think this makes it equivalent. It makes this, a person falling under this, equivalent to one who did go ahead and take the ethics exam, which is an open book thing, and then became inactive, so hasn't been doing all the continuing education, and then wants to go active and has to take a lot of continuing education. I think it makes it equivalent to that, and so I think that's fair.
So I'll entertain a motion. Well, I'll go ahead and make the motion as chair of the committee that we approve this rule change. And I'll entertain a motion, a second to that motion.
Second.
We have a motion and a second. Any discussion? Questions? All right, Karen, we'll do a roll call vote.
Larry Elmore,
Aye.
Janet Booker Davis,
Aye.
Pam Church,
Aye.
John Griesbeck,
Aye.
Judy Weatherby,
Aye.
The third one, to me, even though this one's a little short, one sentence thing, I get lost in the numbers here when I read it. So if you'll follow along with me, this one relates to education and internships. So the rule is amended to delete 6 semester hours, change it to 9, and take out the 8 quarter equivalent and just say or equivalent. So we're basically saying not more than 9 semester hours or whatever the equivalent is, quarter hours. Now, for those of us old enough that we actually had quarters, I don't know who actually does quarters anymore, but maybe somebody does. And then, however, of the 9 semester hours, a maximum of 6 can be applied to the 30 semester or 45 quarter hours that's required in the accounting field. Now, I think correct me if I'm wrong, I think the UAA right now says 9. So we're changing to say what the UAA says too. 9
UAA
semester.
says 9 for
semester.
Accounting or for the 150?
It says not more than 9 semester hours, maybe internship programs.
For the 150 or for the...
So it is 9 hours total in internship. In the UAA, only 3 can be applied to accounting and 3 can be applied to the business hours. So we are a little more lenient by allowing 6 hours towards accounting, and I didn't want to scale back from that. So the attempt here is to still only allow 6 to apply to your accounting hours, but now you can have an additional 3 count towards your 150.
I like that. I think we'd have an uproar if we tried to back off of the number that counts toward the accounting. And since we're trying to be more supportive and bring more people in, I don't think that's the way to go. But I would not support 9 credits going toward the accounting because I think that knocks out too many of the content courses. So I support this.
And it's hard to go back. It's hard to go backwards.
It is.
I know in the UAA committee meeting we were talking about 24 versus 36 months. And one person said, well, let's go 36. And if it's too many, we'll go back later. So there's no way you're going to
It'd be
go
an uproar.
backwards. So that's kind of how we got to the 30, or how the board got to the 30. Okay, so here again, I'll make a motion to approve this rule change.
Second.
Any discussion?
We need the word equivalent in the second sentence. We go out of our way to use it in the first sentence about quarter hours. Is it here?
You mean where we reference 45 quarter hours?
Seems like you would.
It seems to me that maybe the
People getting quarter hours.
nomenclature, or I guess the structure of that would be you would take the word equivalent out and put in what the quarter hours would be. Yeah.
Is there a reason we took that out?
Because it doesn't work out to be an even number. It's like 13.5 or 13.3.
The second reference is easier to calculate than the first one.
Seems like there should just be a blanket statement for the whole set of our rules that there's always an equivalency.
Yeah, it's 13.5 is what it would be if you worked it out. So John, are you saying in the however of the 9 semester hours, we should put or equivalent quarter hours there? Or are you thinking to strike it and replace it with equivalent in the last line?
Not sure the right answer. It just looked inconsistent that we used it.
It's because I'm using new wording and I didn't change all the old wording as well.
Well, I'm afraid if you go down that path, you've got to throw equivalent a couple times in the second sentence, every time. But understandable and clear, then I'm fine with it.
We can say, however, of the 9 semester hours, a maximum of 6 semester hours or equivalent quarter hours. And we'll just stick with the equivalent, even though math does work.
You have to say it again, wouldn't you, at the very end? Were you talking about the 30 and the 45? Wouldn't you have to say it again?
So no, I don't think so. Maybe apply to the 30s. No, because we're talking about 1C is talking about the semester hours that you can apply. So if we're saying not more than 9 semester or equivalent quarter hours, maybe part of the internship program, but then the next sentence, do you want to say, however, of the 9 semester hours, a maximum of 6 semester hours or equivalent quarter hours, which is what we would add, may be applied to the 30 semester or 45 semester.
35 quarter in a.
That's probably the answer, because the 30 and 45 is already set in another rule. So I see that. So that probably just needs to stay the same there.
Do you guys be okay with after? So like where it's the sentence that starts with however, comma, after it says 6 semester hours, I was just going to add the phrase or equivalent quarter hours. What does that feel clear to everyone?
I think it does, because it's with the however clause, it's clearly referring to the preceding line.
Yeah.
And that limits it, which I think is appropriate.
We can also provide another printout tomorrow, just so everyone's clear and no one's confused about the change.
I think you should also put the number 6 in parens just to be consistent with the rest of the sentence. Near the word 6.
Okay, so I'll amend my motion.
It's like, are you watching me?
So I'll amend my motion to agree with that change, and we'll need a second and probably need to revote.
I don't think.
Not vote. Okay. So I'll amend my motion to agree with what Laura just said. I told you this one was more confusing than the other ones. Second that, okay. So I think we're ready for a vote unless there's more discussion.
Larry Elmore,
Aye.
Janet Booker Davis,
Aye.
Pam Church,
Aye.
John Griesbeck,
Aye.
Judy Weatherby,
Aye.
Chairman, I think that's all the Rules Committee has.
All right, thank you. Now we're going to move over to enforcement. We have on enforcement our chair, Kevin Monroe. Some people in here may not know that he is also our past chair and does an out. So I'm going to turn it over to him.
Chairman, the first thing I'll do is just highlight the case and complaint report, and the area I want to emphasize is down at the bottom of that report where it's addressing complaints opened by year, and just taking a look at the trend in our complaints. We note that in fiscal years 19 and 20, the earlier of the 5-year period presented here, our complaints were relatively in the mid-90s per year. And then they dropped significantly beginning in fiscal year 21 and really have stayed fairly steady through fiscal year 23 to date. I think part of that is due to potentially part of it is due to just a drop in activity relative to COVID, but I think also a significant part of that is because of the changes that the board approved with respect to CPE documentation when folks are applying for renewal. They have to provide a little more information up front, which I think has minimized the number of CPE non-compliance cases that have had to have been opened. And so I think that was good policy on the part of the board and also great compliance on the part of our practitioners, because I think we moved from a roughly 75% rate of compliance in our audits, our CPE audits, to well over 95% compliance generally since that rule has been implemented. So some good news there, and how kind of addressing an issue can really, we have some capability of getting some improvement. Now we'll move to the legal reports, and we have a variety of cases here before us. The first 8 cases are in what we call our consent agenda, basically meaning that there is no separate proposed discipline. And typically what we do is we review each case, discuss it, and then have one motion to deal with the outcome of all of the cases in the consent agenda items, unless someone needs to recuse or we need to separate one out for one reason or another. So if people are comfortable, that's how I'll proceed as we review these. The first item in the consent agenda is case number 2022-04-3121. This case is basically about a complaint regarding failure to exercise due professional care and in communications with the client. And in essence, the complainant had paid money for the preparation of a 1040 tax return, but indicated that the respondent had never filed the return. Also indicated that the respondent's son was somehow operating under the father's CPA license and therefore falsely representing himself as a CPA. A respondent stated that they did prepare the complainant's tax returns and copies were given to the complainant on multiple occasions, but that the respondent states that the complainant never provided them with the form authorizing them to electronically file the return in question. Also, the respondent indicates that the owner's son has never been listed as a CPA on any firm or client documentation, nor have they ever represented themselves as a CPA. So the investigation was completed. The complainant now says they no longer believe that the respondent's son was operating unlicensed. They just say that they were previously unaware that someone who is not a licensed as a CPA could work in a CPA office in any capacity. The investigator was also informed that the client has since provided the form authorizing the electronic filing by the complainant and that the returns were filed, and therefore there does not appear to be any evidence of violation, so we recommend closure. Any further questions or discussions on that? I'll proceed to item 2, which is case number 2023-002291. This is essentially a complaint about a person who was working for the company respondent. They then resigned from their position and alleged that the respondent failed to provide them with all of their personal belongings and final check at the time of their separation, and alleged that the respondent's behavior was unethical. The complainant has since requested to withdraw their complaint and states that the matter has been resolved. Therefore, counsel recommends closure. Any questions with respect to that? We'll go to item 3, which is case number 2022-043701. This is a situation where the complaint alleged that the respondent didn't provide the appropriate accounting and tax records when requested. The complainant states that they were a partner in the respondent's business in 2021 and therefore believe they should have been consulted on the business's taxes in 2021. And the respondent also stated that they believe they are entitled to copies of all the returns. The respondent states that the complainant was a member of the business and not a partner, and the respondent was able to provide an operating agreement showing the complainant was a member. The investigation was conducted. The investigator noted that there did not appear to be any evidence of violations committed by the respondent, and that the investigator notes that there seemed to be confusion on the complainant's part as to the nature of the organization and the rights that came with their position. As such, counsel recommends closure. Any questions on that one?
I have one question or comment.
Sure.
Is there a difference between a partner and a member, other than being an LLC member? Is there a difference? I mean, I would think they would be the same sort of rights, other than an operating agreement dictates what it would be. I was confused by that part. I mean, do we know anything further about that?
Yeah, I'll let counsel respond first, and then I have my own view.
Yeah, the complainant thought they were in a partnership. It was actually an LLC. So they kept referring to themselves as a partner, and they had certain rights, but they were just a member of the LLC.
My point is, I think that's the same. Essentially, is it not? I mean,
organizationally, I don't think it is. In terms of a partnership, in terms of what rights you have.
No, I'm talking about rights of an individual owner.
Right.
Who is either a member or a partner. And I think it's semantics almost, is it not? I mean, it's not important. I'm just curious as to why that was even mentioned.
I think the respondent was just trying to clarify because they provided the operating agreement. This person was calling themselves a partner over and over again, calling them in a partnership. And I think he was just trying to clarify they're an LLC. He's a member. Here's the operating agreement. Here it is. And so it was just kind of included to give the full view of the respondent's answer.
It just didn't really matter, though, right?
But the LLC, is it not being reporting as a partnership? And there's a 1065 filed. I mean, an LLC can be taxed as a corporation, a single member LLC, a partnership, or even go to S Corp. And so if it's a partnership and he is a member of that, he gets a K-1. So I'm like you, I was kind of confused with the terminology because member and partner can be basically the same thing because a partnership return is actually filed for that entity.
I guess the distinction is controlled by the operating agreement, regardless of what you call yourself. And it just seems like they were making a distinction. Oh, I'm a member versus a partner. Therefore, there's a difference in what documents I can get.
I think more they were just trying to clarify the complaint.
Okay.
They provide an operating agreement. It states member in it. So I think in their response, they were just trying to clarify this is how how he's operating within our company. And so I just was providing the information that they provided.
Okay.
And they're
Good questions and comments raised. Any further comments?
Yeah, and they were no longer a member at the time that the incident occurred.
Okay. All right, we'll proceed to item 4.
That does make a difference. That's the difference, sounds like.
Yeah, that's what I'm trying to clarify. That sentence was just meant to be just a clarification. Like they were providing the operating agreement. The operating agreement says member. They clarified in their response they're not a partner, they're a member. I think they just wanted it clear for the record of how they operated within their company. So that's just a clarification point.
Thank you.
I think, counsel, if you could add that, for tomorrow's presentation, that last fact that they were no longer a member, that would be helpful. We'll go on to item 4, which is case number 2022-046-401. This is a case involving allegations of independence, lack of independence, and due care. The complainant alleges that the respondent had a financial reporting violation. Well, let me give a little more background. So the complainant first stated that the respondent violated the independence requirement by performing accounting functions for a county emergency communications district. The complaint explains that the county emergency communications district was also an audit client of the respondent. And the complainant stated that the respondent performs all accounting, bookkeeping, and payroll functions for the county emergency communication district, as well as then did the independent audit report for that same district. They also alleged a financial reporting violation, contending that the audit report that the respondent was in charge of contained incorrect statements and information. According to the complainant, the respondent has not followed proper procedures to correct the audit report and failed to recall the audit report and or issue a corrected report. An investigation was conducted, and during that investigation, the respondent explained that they did not violate the independence requirements, as their audit engagement was within the confines of the appropriate AICPA rule set with respect to independence, which provides that there are various instances where independence is not impaired when performing certain services for an attached client. The investigator confirmed that their engagement with the client mentioned in the complaint falls within these exceptions. The investigator also did not find evidence of an independence violation on behalf of the respondent. Additionally, another complaint was filed against respondent with the Comptroller's Office for the same allegations. The investigator coordinated with the specialist in the Comptroller's Office, who confirmed the matter was closed by that office after a determination was made that there was no impairment to any independence requirements. Additionally, the investigator confirmed that there were no unanswered issues or violations within the respondent's audit report as alleged in the complaint, and the Comptroller's Office confirmed the audit report issued by the respondent was essentially correct and that there were no further corrections necessary, and as such, counsel recommends closure. Any comments or questions with respect to this one? Larry?
Chairman, I have a question on that. In my latter years of my illustrious career, I did a lot of governmental auditing, and near and dear to the heart of a governmental auditor is what's called SKE. SKE is the acronym, and what the governmental accounting independence rules say is that unless a person on the client's staff has SKE, which is skills, knowledge, and experience, that's what that stands for, that who is supervising everything that the firm does and approving it, signing off on it, that you're in violation of the independence rules. So I'm assuming, based on reading this, that someone on the staff of the 911 district had SKE. Now, it's hard to believe where the sentence says that the firm was performing all accounting, all payroll, and prepared the audit report. It's hard for me to believe that they weren't violating something. I was going to ask our investigator, do you know what the exception was that they fell within?
Well, I just talked to the Comptroller's Office and talking to the respondent. They don't have control over any of the books and records. They can't independently make any decisions about the books and records.
I was looking for something that said that in here, and I didn't see it anywhere.
The complainant just alleged those things that you were mentioning prior. I wasn't saying that it's a fact. That's why I was saying that the complainant states that respondent performs all these things. Maybe I should have put a little bit more clarification in there, but that's not. I wasn't saying that as factual. That's why I put state or alleged before it, because the complainant is just alleging those things. That's the information that they had based off of something that they believed. But based on the evidence we found, we didn't believe that that was an accurate allegation.
So assume that somebody on their staff was supervising everything that was done. Somebody on the client's staff, because that's what the specific rule says. So if the comptroller's office signed off on it, I guess that's okay.
Yes, that's correct.
Any further questions on that item? We'll go on to item number 5, which is case number 2022044721. In this particular case, there is an allegation for an ethics violation where the complainant states that the respondent was engaged by the company in July of 2021 to serve as a controller for their 2 businesses. They were then promoted to CFO in January of 2022. The complainant now alleges that the respondent acted in a grossly negligent manner in their position by indicating that they improperly paid themselves as an employee and failed to timely file their tax returns. Respondent denies all allegations by complainant and states the work complainant hired them to do has been completed and payment authorization was continually and explicitly given to the respondent. The respondent is not a licensed CPA, and there was nothing in the complaint alleging respondent had ever expressed that they were a CPA or held out as a CPA. So after a review of the complaint, the response, and documentation, it does not appear that the board has jurisdiction over this dispute, and as such, counsel recommends closing the complaint for lack of jurisdiction. Any questions on this item? Okay. Yes, absolutely.
So, I'm going to answer that, or yeah.
Please.
So typically, what will happen is if a comes to a centralized complaint area, and if they believe that it doesn't have jurisdiction, they'll send it to the program attorney, which we've been without since Savetta left. So, and they'll ask, "Do you believe there's jurisdiction?" Sometimes it's unclear if there's other issues within it, and so they'll open a complaint anyhow, have it go out for investigation, if it comes down to it. And then sometimes you can read a complaint and know within a moment there is no jurisdiction, so we'll just tell them not to open a complaint. But sometimes centralized, they read it and they don't think that it's going to be an issue, so they open it, and once it's open, it has to come through the process. Yes, yeah.
That's a good question, and appreciate the clarification on that process. Any further questions on that one? We'll go to item 6, which is case number 2022052691. This is essentially a lack of due care type of complaint, where the complainant indicates that they hired the respondent to provide them their depreciation schedule so that they could determine what they would have to pay after taking an accelerated depreciation on their property and to inform them what their estimated tax payments should be. Complainant states that the respondent spent an additional 12 hours performing work that was not requested by the complainant, and that they filed their complaint because they disagree with the hours that the respondent billed them. And respondent states the billing issue has since been resolved. Since this is essentially a billing disagreement and not on an alleged violation on the respondent's behalf, counsel recommends closing this complaint due to lack of jurisdiction, as this board is not the venue to decide a billing disagreement. Also, the billing matter has since been resolved, and the complainant and respondent no longer have a working relationship. Any questions on that one?
Chairman, I have a question on the wording here.
Okay.
Where it says they wanted the schedule so they'd know what they had to repay. Wouldn't a better term there be recapture?
That's just the words from their complaint. That's what that's based off of. So kind of in the summary, you're just putting in within what they file in their complaint. I'm just kind of summarizing that. So that's off their wording, but I can change the word if you'd like me to.
Okay, I see what you're saying. That's just what they call it.
It's what they put within their complaint. And so I'm just kind of just trying to summarize their voice so they feel like their complaint is being heard. So sometimes I use the words that they use. Sometimes I change the words that they use, but I can change it if you like. It's not a big deal.
Okay. I didn't that it said that's what the claimant said.
All right.
Just wanted, since these are talking about accounting terms, I think that we as a board should use those kind of terms in our reports or in our discussion, so it doesn't look like we're.
I could change it. It's not a problem.
But now that I've looked at it, I'm okay with it.
Okay, so we'll plan to leave that as is. Any other questions or comments on this one?
Maybe that's something that could be put in quotes since it's from the complainant. The repaid language.
Okay.
Yeah, I like that.
We'll capture that. Thank you, Janet. We'll go on to item 7. Item 7 is an improper use of the term accounting case. The Board of Accountancy received notification that a respondent appeared to be operating without a firm permit while having the word accounting in their business name. And the search of the respondent's file confirmed that they do not hold a firm permit. When the respondent was contacted, they apologized for the mistake and explained that they are not a CPA, they have no employees, and that they just do bookkeeping and tax preparation work. They stated that they would remove the word accounting from their name to come into compliance. An investigation was conducted. The respondent did provide an affidavit and proof of name change with the IRS and again apologized for being unaware they could not use the word accounting. Respondent is not registered with the Secretary of State. Accordingly, counsel is recommending closing this complaint with a letter of instruction reminding the respondent of the requirements under the relevant Tennessee Code section. So the recommendation again is to issue a letter of instruction reminding them of the requirements. Any questions on this one? Looks like the respondent was immediately responsive when they were contacted about this.
Yeah, that's correct.
Okay. All right, we'll proceed on to item 8. This is a case concerning possible operation without a firm permit. The Board of Accountancy received notification that a respondent appeared to be operating without a firm permit. There was no record of respondent obtaining a firm permit, and so the complaint was opened.
Case number, please.
I'm sorry. Thank you very much, Robert. This is case number 2023-001801. The respondent stated that they were a single-member LLC and do not do attest work, that they only provide tax services, tax return services, and based on that information that they were given when they applied for a license, they did not believe that they were required to have a firm permit. Respondent has since applied for and been granted a firm permit and states they apologize for not understanding the requirements with respect to a firm permit. The complaint was opened on January 12th of 2023, and the respondent was approved for their firm permit on January 20th. Due to the client's remorse and their quick action to obtain a firm permit after the complaint, counsel is recommending closing this complaint with a letter of warning, reminding the respondent of the requirements relating to firm permits. Any questions on this item? Okay, I think that concludes the 8 items that are on the consent agenda. And so at this time, I would, as chair of the committee, make a motion to accept the recommendations for each of these 8 items in the consent agenda. Are there any further questions? Well, I guess first, is there a second?
Second.
We have a motion and a second. Is there any further comment, question, or discussion? Not. Karen, will you please call the roll?
Evan Monroe.
Aye.
Greg Gilbert. Gay Moon. Rob Vance.
Aye.
Okay, that motion carries. We'll go on now to the proposed discipline section. These are cases where we typically have counsel or staff recommendations for actual discipline. And so we'll go ahead and start with item number 9, which is a case involving an allegation of lack of due care. And this is case number 2023-000-191. So in this case, the complainant is stating that there were demonstrable instances of the respondent misrepresenting facts. Complainant states, as a licensed professional, they think respondent's actions warrant investigation by the board. The respondent's attorney indicates that it was unfortunate that the complainant has attempted to gain an advantage in ongoing civil proceedings by filing the present complaint, and states that their client has vigorously defended complainant's claims and looks forward to presenting their defense in court. The attorney expressed that the respondent believes the complaint lacks merit and is without cause. An investigator confirmed the respondent and complainant are currently in ongoing civil litigation pertaining to the allegations in the complaint, and so counsel is recommending placing this matter in litigation monitoring until the civil litigation is completed. Any questions with respect to this one? Okay, we'll go on to item 10, which is case number 2022-033-211. This is a case involving allegations regarding the filing of a false tax return. The complainant states that they filed their complaint at the advice of an IRS officer. They indicate they made an appointment with the IRS to review their previous tax filings after receiving multiple threats from the respondent who prepared their taxes. During their meeting with the IRS agent, the complainant states that they were informed that the respondent reported that they paid complainant various dollar amounts in 2018 and 2019 and provided them a 1099. Complainant states, however, that they never received any money from the respondent and do not know where the alleged funds went. The complainant states they were not previously aware respondent filed any untrue paperwork on their behalf and believe that the respondent had taken advantage of their lack of knowledge of the English language to benefit at their expense. The complainant states that they put their trust in the respondent and allege the respondent used this trust for an improper purpose. The respondent states that they do not have any records of filing federal tax returns for the complainant in 2018 or 19, and states that they only issued complainant a 1099 miscellaneous for 2018 and 2019, and that any refund money received was already paid to complainant previously. Respondent states that there is a civil case currently ongoing between the complainant and the company respondent is involved with, and asserts they never threatened or defrauded the complainant. An investigation was initiated. It was confirmed that this matter is currently in civil litigation, and counsel, as such, recommends placing this complaint into litigation monitoring until that is completed. Additionally, the investigator determined that there was evidence of possible criminal activity involved in this complaint, specifically the filing of a false return, and recommends that this matter be referred to law enforcement. And for that, I guess I'd turn it over for some kind of commentary, Duke, on that one. And in the context, we've had some cases in the past where there might have been an initial inclination to refer something to law enforcement, and basically we deferred to the complainant to be the one to do that versus the board doing that. And so if you could elaborate on that, either you or counsel, that would be helpful.
Typically, I haven't had a case like this with this board yet. Other boards and commissions, they do typically refer things to law enforcement if they believe a crime has been committed, either law enforcement, attorney general, so on. Typically, it's on the complainant if they want to instigate a civil litigation matter. However, when there's a criminal aspect, the other boards and other commissions tend to do that, but it is at your discretion if you want to. It's just something that me, Wendy, and Duke had discussed, that since there was a criminal aspect to this complaint, that potentially just going ahead and referring to criminal to law enforcement for them to investigate might be the beneficial thing to do for the complainant, but it's at your discretion.
So this would mean that the board itself would be making some type of a
So we don't necessarily make a complaint. Our centralized complaint center will just take the information and they'll just send it over to the proper department within law enforcement, and then they can decide if they want to pursue it or not. It's just providing the information. We're not filing a complaint. They're not going to call you. They're not going to do any of that. It's just giving them information.
Okay.
Yeah, but I had the same concern. Go ahead, Greg.
In this particular case, though, would the law enforcement not actually be the IRS?
We had discussed that, yeah.
Who's already involved? Maybe, or we don't know, I guess.
Well, just to give you context, is the complainant went there to figure out what was going on. And when they sat down, they said an IRS officer, take that with a grain of salt, that's civil. That wasn't someone within the law enforcement within the IRS, because the IRS has a very small law enforcement component. And there is a pretty big dividing wall between the civil and the criminal. And so he sat down with what we believe to be just someone with the civil side to kind of explain what his return was, what was there. And the concern is, well, if he's including income that he didn't actually earn, but that was on his return, it's kind of usually people don't claim their income on the return. This is a different way, but it's still technically a violation because it's a false return. That's still, potentially a felony. And then there's another concern that is this respondent somehow maybe parking false, expenses on unwittings, returns, in an attempt to hide their own income, if that makes sense.
Another option may be to refer to the IRS Office of Professional Responsibility, who I think would handle these type cases.
Yeah, I think because it's a criminal violation. It's the 7206. That's why I was thinking criminal investigation.
It's at your discretion, whatever you prefer. We don't have to refer it at all. We can refer it to whoever you guys want. It's just kind of an option. It's just a way for you to get the information to the correct people. It's just it's pretty common across other boards and other commissions. I work with another one that has frequent criminal activities, and we refer it quite a bit, but it's whatever you guys are comfortable with doing. It was just an option. I don't know if Wendy wants to speak on it more.
Is there an option to refer to both parties, the OPR and law enforcement?
Yeah, we can send the information to whoever they want to send it to.
Well, the OPR is usually for an internal review of internal employees within the IRS. That's what in my former employer, that's what it was. The professional response, unless there's another one for like tax preparers or some sort of.
Did you talk to the IRS agent that was involved in this? I mean, this is a bizarre case for a CPA to issue 1099s that are bogus.
We put the investigation on hold, so he just filed in litigation because we didn't want him to proceed on it, and then a court order come out. So I instructed him not to go any further once we confirmed it was.
So we haven't talked to the IRS agent or seen.
Correct. Yeah. That's why we just have basic information. That's why we just want to refer it, so that way, if they feel that way. But again, it's completely at your discretion. It was just an option.
I'm just wondering, like, why would it? Is it had to do with like earned income credits or something like that, where they could get, if they're claiming income they don't have, so they could get refunds from the IRS?
No, I think what he's doing is again, I'm speculating here because we put a halt on it. I think he's taking it, or this person may be taking advantage of their clients that may not know very much about their taxes or their tax returns, and concealing their own income by claiming it's an expense somewhere else. If that makes sense.
Oh,
see what I mean?
Okay. The accountant is issuing 1099 so he can take deductions on his return.
Yes, that's exactly. Yes.
Okay, I got it now. Allegedly.
Yeah, allegedly.
Excuse me.
Allegedly.
Yeah, we don't have any information, and that's why we kind of wanted to go through the civil process, which is what we typically do when there's a lawsuit initiated, and then we kind of go off of what is found within that.
But Duke, I thought you said a while ago that you talked to an IRS agent about it.
No, I did not talk to an IRS agent about it.
Okay.
No.
The complainant just stated in their complaint that they spoke with an IRS agent. Yes.
Yeah, I just have a concern that, I mean, maybe we've done this before. I don't remember. I can remember us referring cases to another board, like the contractors board or something, or them referring to us. And I don't remember ever getting in the middle of a.
It's pretty common in other boards and commissions. I just think this one's not a board that gets too many criminal activities within it, and so maybe that's why. But we totally don't have to do it. We can just take that part off the recommendation. It's completely up to you.
Luke, another question I had was, where you say any refund money received had already been paid to the complainant. Was this tax professional getting the refund or something? Was he getting their refund?
That's what the respondent wrote in their answer. Like I said, we haven't investigated into it at all because we're just placing it into litigation monitoring. So we don't have direct information from an investigation. The respondent just stated in their response, any refund money that was due was given to the complainant. So I don't have exact answers on the terrain that it went through because we haven't gotten into it yet.
The law enforcement language is fine with me, but just to clarify, at the IRS, the Office of Professional Responsibility basically regulates tax return preparers. So that would be the appropriate, or one of the appropriate venues for this case. But they're probably deemed to be part of law enforcement. So
I think the language law enforcement could be interpreted broadly enough that maybe we could say appropriate law enforcement or relevant law enforcement here.
Yeah, I speak with centralized. We discuss who it needs to go to, and they send the information there. That's pretty common language for things that have been recommended in the past is to write law enforcement, but I can specify within the recommendation.
Yeah, I think it may have a different name than OPR. I think it might be like Treasury Inspector General Tax Administration or something like that, because I do remember my past history working with somebody like that.
Okay.
So let me say one more thing. I guess my concern is that we're relying on information provided by this claimant that already in reading this doesn't make much sense, and that we're going to refer this to somebody else to move forward with, but we're basing it on information that we're not sure about.
This is just something that me, Wendy, and Duke had discussed. It was just an option we wanted to provide you, just because there was possible criminal elements within this complaint. It was just an option we discussed. Like I said, yeah.
I would remove the reference to law enforcement until the civil has been determined, because it may be it turns out that the claimant didn't understand some of these terms and really things weren't filed inappropriate. I don't know.
That's my
point. But I would wait, and then if it comes back and the respondent is found guilty, then I would put in there to refer to law enforcement. But
I agree. I think we need to be cautious about referring to law enforcement if we haven't really investigated, and these are allegations that we don't even know enough to, or haven't confirmed the validity of it. So I'd be concerned about referring something to law enforcement at this point.
Okay, we can just delete it. It's not. We can just take it out of the recommendation.
But is there a way for us to monitor that going forward to see what happens?
The recommendation is for it to go into litigation monitoring. So yeah, I mean the case will stay with us.
Yeah, they should hopefully update either me or Duke, the attorneys, once it's moved through civil litigation. And at a certain point, if I don't hear from them, I'll reach out to them.
And I'm not on the committee, but I like Gay's recommendation.
Janet Booker Davis also liked that recommendation from her comments. So, as the chair, I'm kind of hearing that there's not a consensus to include referring this matter to law enforcement at this point. And so I think what I would recommend is that we strike that element from council's recommendation, the element meaning refer to law enforcement at this time, and proceed accordingly. Is there any further kind of discussion or feel on that issue? All right. So when we vote on the proposed discipline items for this particular item, number 10, we will be voting on the assumption that we are striking the phrase referring to law enforcement. Ready to proceed to item 11? Now this is, there are 4 case numbers associated with this one, 2022-034971, 2022-034981, 2022-034991, and 2022-035001. This is a case involving acts discreditable, and it is a unique case, and it's a rather lengthy one, but I think it merits some kind of review and discussion here. So I'll try to summarize based on the information that we have in the legal report. In this particular case, the respondent has already been disciplined by the Securities and Exchange Commission for violations based on the allegations that the respondent encouraged and facilitated cheating on the AICPA ethics exam and the knowledge assessments part of CPE courses provided by the respondent. After this determination, the SEC required the respondent to evaluate the sufficiency and adequacy of their quality controls, policies, and procedures relevant to ethics and integrity, and to responding to information requests, and then report their findings to the SEC. They were also required to retain an independent consultant who at a minimum demonstrated expertise in designing or reviewing compliance policies, procedures, and controls relating to ethics and integrity, and they were required to designate a 3-person committee of senior personnel who were not involved in the aforementioned violations to direct and oversee the employment and other remedial actions on behalf of the respondent. The respondent was ordered to pay a civil penalty in the amount of $100 million to the SEC and to cease and desist from committing or causing any violations and any future violations of PCOB Rule 3500T. They were required to provide their audit clients and SEC registered broker-dealer audit clients a copy of the SEC order implementing this discipline. There's some additional background with respect to this, but ultimately There were kind of two facets here. Through the investigation, it was determined that a significant number of the respondents' audit professionals cheated on their CPE knowledge tests, which were required to be completed with a passing score by using answer keys and sharing them with their colleagues. Also, a significant number of respondents' professionals who did not cheat themselves but knew their colleagues were cheating and facilitating cheating, violating the firm's code of conduct by failing to report this misconduct. The number of employees either sharing or knowing the activity was occurring appeared to be systematic throughout the respondents. There was no evidence of any Tennessee licensees using or sharing answer keys for the AICPA ethics exam. So in response to this complaint, the respondent's attorney provided an answer naming individuals in Tennessee who were involved in or knew of the cheating. Respondent additionally provided more detailed information pertaining to the individuals who were involved or knew of the cheating. That sounds like a duplicate sentence there. We'll strike that. And the number of occasions on which an employee sent or received answer keys and or the time period an employee knew of the cheating but did not report it. Respondent identified one unlicensed employee who is based in one of the respondent's Nashville offices who received answer keys for CPE assessments, and the firm's investigation found evidence suggesting use. The respondent disciplined the employee by imposing a reduction in their salary, counseling them regarding their ethical responsibilities and their duty to report suspected misconduct. Further, the respondent identified 14 employees who shared at least one answer key for a CPE assessment. 11 of the identified employees were from one of the respondent's Nashville offices. One was from one of the respondent's Chattanooga offices, and the last two were from offices outside of Tennessee. 12 of the employees maintained a Tennessee CPA license, while the other two were unlicensed but worked in one of the respondent's Nashville offices. In addition, they identified 13 employees who maintained a Tennessee CPA license and were aware of potential violations of the code. Specifically, these employees had knowledge of possible violations because they either received at least one answer key or were aware of other individuals sharing the keys. 10 of those were from one of the respondent's Nashville offices, one was from the respondent's Chattanooga office, and the last two were outside of the offices of Tennessee. There were no employees above the manager level identified as being involved in using any answer keys, sharing them, or knowing about them and failing to report their use. Any employee identified at a higher position were punished with either a delayed promotion, a fine, or a reduction of salary, depending on the totality of the individual's history. There were no Tennessee licensees at the partner level that were identified. The respondent indicates that they have revamped their educational delivery system in order to make it more difficult for employees to share answer keys. They now require professionals to take specific training courses on the topic of integrity, ethics, and honesty in taking assessments. They require their people to certify in writing before taking internal assessments that they are completing the assessments on their own. They have revised their policies on learning, and they have also required an annual Global Code of Conduct certification. They have implemented a required pledge in which its people promise to live the respondent's values every day, including a commitment never to cheat. This pledge is renewed annually. They have also implemented learning days and similar initiatives in each of their service lines to underscore the importance of making time for professional education. They have made available free of charge college-level course materials on professional ethics in the digital age. A complaint was opened against each of the 4 offices the respondent has located in Tennessee. The investigation discovered that there was no evidence of employees at 2 of those locations, respondent's Memphis office and second Nashville office, being involved in any violations. Accordingly, counsel recommends closing complaints relative to those 2 offices. However, for the 2 remaining offices that identified employees in violation, the respondent's Chattanooga office and their initial Nashville office, counsel recommends assessing a $1,000 civil penalty per employee involved. Based on the investigation that there were 28 employees identified, accordingly, counsel recommends assessing a $28,000 civil penalty for these 2 offices. And I believe we're talking about at the firm level. Is that correct?
Yes.
Not at the individual level, at least at
yes.
this point. Additionally, there were 2 employees who stood out as a possible concern due to the number of answer keys sent. One sent answer keys on 22 separate occasions. The other sent them on 27 separate occasions. The number of occasions these 2 employees sent answer keys is more than triple of any other employee identified, and council recommends the board discuss whether to open a separate complaints against these 2 individuals. So to recap here, the council's recommendation is to close the complaints against the 2 offices that had no individual violations, and to authorize a formal hearing with the authority to settle via a consent order upon the respondent's payment of a civil penalty in the amount of $28,000 for the 2 offices with the employees identified. Finally, council recommends that the board discuss whether to open separate complaints against the 2 identified individuals who egregiously shared their answer keys. I think before we go any further, I think I'll just open it up to Wendy and council. Is there any further background information that you would like to share with the board? And then I kind of have a framework for kind of guiding our conversation around this, because there are at least 3 different kind of decision points that we need to make here.
I think the only thing that I will add that, and I'm sorry if I missed it, I just didn't think I heard it in here, but that the firm has also implemented a process similar to the CPA exam where when you take continuing education, no 2 people will get the same question, so therefore possible cheating going forward would be very difficult because you couldn't share an answer key that would work on the next assessment.
That's briefly mentioned in the.
Is it? Okay.
Yeah.
Yeah. Okay.
Yeah. Yeah, that's a more explanation of what their system is now.
Thank you. So to kind of recap here, basically, this is a complicated case involving a national firm. And so, one issue is basically the recommendation of fining the firm, the firm in Tennessee, the 2 firms that have permits here, $1,000 for essentially each of their employees that were deemed to have made these violations. That's one kind of section. The other section is basically what, if anything, to be done with the 2 employees who more egregiously seem to share a great number of answer keys relative to their peers. And then we have as the backdrop for that the fact that the firm has already been fined significantly by the SEC and entered into a very significant order regarding their remedial actions. And so at this point, let's just kind of open it up for discussion amongst the committee or other board members that have questions on this in terms of their thoughts, and maybe just to guide the discussion, I'd like to start first with the recommendation on the $28,000 civil penalty that would be directed at the firm, not the underlying individuals in that case.
Can I just ask for clarification? So there's a line in here that says there was no evidence of any Tennessee licensees using or sharing answer keys for the SCPA ethics exam. Does that simply mean that all the cheating that they found in Tennessee was on CPE knowledge tests? Is that all that means?
That's correct.
Yes. Yeah. Knowledge tests that the firm would have had its employees take to gain CPE hours, but not testing, to be fully licensed. Yes, that's how it's interpreted.
There are instances of it in other states, but not within Tennessee.
Oh, so this happened on a national level then, not just Tennessee? Okay.
Yes.
All right. Thus the $100 million fine.
Yes.
Okay.
Yes,
Thank you.
yeah.
I do have a question about the 2 individuals. So did it start with these 2 people? Do we know that? They sent it out 22 and 27 times, I guess, to their...
I don't know if it started with one of them was a manager at the time they left the firm. So they left as this investigation was going on, but they were in a leadership role and they were doing this. And they were the most prolific at it.
In Tennessee?
In Tennessee,
okay.
Yeah.
I mean, but they were one of the leaders in Tennessee or nationally?
In Tennessee.
Okay, all right.
Wendy, did we discuss this or a similar case previously? I distinctly remember discussing this situation when we were in a different conference room and somebody, we
think the
went into a
news just hit or
discussion.
something. We read, someone
Was it
read about
just
it.
the news? I just wanted to make sure we have never considered this in an official capacity.
So the order came down from the SEC in June of 22. Is when the
Guess
order
that's
was
what
made
happened.
public.
We were just discussing it. Okay.
In fact, I think several members of this board were in attendance at the NASBA Eastern Regional meeting when the news nationally broke.
Wendy, do you know what some of the other states have done with respect to penalties in this situation?
Yes, California and North Carolina have both issued discipline. North Carolina just announced it last week. I believe they issued a $15,000 penalty. Correct me if I'm wrong, Kevin. I shared this with Kevin. $15,000 penalty. I don't believe they had any individual licensees in North Carolina, is how they stated it.
Yeah, and you're right on the $15,000 assessment that they issued.
What do you mean they didn't have any in?
I believe they were unable to confirm that there were any licensed individuals at the time the violation occurred.
Yeah, and in fact, based on the information you sent, and this is from the North Carolina board summarizing their disciplinary actions, they indicated that after investigation, this board, meaning North Carolina, had determined that none of the firm's employees indicated in the order were licensed in the state of North Carolina during the relevant time period. So they went ahead and still
Wouldn't that
issued
be
an
because
assessment.
they were trying to become CPAs?
Possibly.
It could be.
They were taking
No repercussion. Does someone have repercussions if a person cheats, say on the exam or something? I mean,
Their discipline item does go on to say, that, again, this is North Carolina, the firm identified only a small number of employees who engaged in the aforementioned CPE-related conduct. So I think that earlier reference to none was with respect to the AICPA ethics exam, similar to our case. But they say they identified a small number of employees who engaged in the CPE-related conduct who are currently licensed in the state of North Carolina, but none of those were licensed in the state of North Carolina at the time of the conduct.
When I have a comment, first of all, I'm having trouble coming up with 28. The 28 includes 2 individuals who are unlicensed. Is that what we're trying to? Are we intending to include them?
Yeah. Yes. Yes.
So even though they're unlicensed, we're including those. And I'm fine with that. I just want to make sure my math.
Yeah, so we had discussed that quite a bit. It's just because it's going to do at a firm level. Just because it was an employee, technically we were including them within the 28
So
that we came with.
if this first discussion is about the firm level,
it is.
Shouldn't we consider the fact that there were multiple violations by these people, and that the firm did not have adequate controls in place to catch the fact that these people were doing it 15 and 16 times?
Well, I think that's what that one paragraph is speaking on, the changes they've made since then, and the type of safeguards they've implemented in order to ensure that it doesn't occur again.
But that has nothing to how we assess our penalty.
No, it doesn't. I was just saying that was a.
I think our penalty should take into account that their controls were not adequate to keep it from not only happening, but not adequate to keep it from happening 22 times by one person.
I just meant that as a mitigating factor, which is something that we discussed, is the changes that they've made since, and having the SEC order come down and the steps that they've taken. It was a way to mitigate kind of all of the issues and still penalize them at $1,000 per person. But I mean, you have the capability to penalize more if that's something that you want to discuss.
I'm not on the committee, but I just want to. The firm, in and of itself, that has that many people that are involved in a cheating scam at that level and with managers or supervisors involved, I mean, I'm shocked. That shocks me as trying to protect the public, which is what we're supposed to do. If they can I mean, they got caught. I don't know how they got caught, but what else are they willing to do? You know what I mean? Where's the line? There's no line. There's, you're either above or below, and I don't know. I have a big problem with that whole thing.
SEC, it states, disciplined them on allegations that the respondent encouraged and facilitated. That sounds like, it doesn't sound just like poor quality control. It sounds like policies that said, here, let's make sure our people pass.
Let's make sure our people pass, and here we're going to pass these out. And
Yeah, that's my point.
I think for me, and just personal opinion on this, I mean, I'm looking at the price that has been paid because of the SEC's $100 million fine, and then the resulting order of all the remedial actions that they need to take. At least on individual cases, traditionally, we've not really piled on and added additional penalties. Once a person has discharged their SEC orders and paid their fines and so forth. And so when I read that council was recommending the $1,000 basically per violation because of the 28 instances that had occurred in Tennessee, at least I shouldn't say instances, the 28 individuals who may have committed one or more instances of violations here. I thought, okay, I'm not sure what kind of an incremental message that would send in comparison to a $100 million fine and the other remedial actions that they're taking. But I asked Wendy the same question that some of you did, which is, well, what are other states doing? And, some are, like North Carolina, they did issue a fine. I might be inclined to feel differently if we had any instances of people who cheated on the licensing, the ethics part that results in being licensed. There were none here, apparently based in Tennessee. And so, I'm struggling with this one in terms of what incrementally do we do. This is a widespread matter that affects a national firm, and the SEC, came down hard. In fact, one of the SEC commissioners dissented strenuously, thinking that the $100 million fine was overkill for the violations. But the majority of the SEC commission determined to approve that punishment. And so I'm struggling myself and would welcome other thoughts or comments from folks.
I do see the CPE courses as being quite different from the AICPA ethics course. For one thing, CPE courses are all structured differently. So if you go to a day of CPE, you virtually may not have to do much of anything to earn your credits. You might be able to sit there and read your phone. But that doesn't justify, don't get me wrong, but it's not the same level as the AICPA. And I did wonder about that, Kevin, as far as that's a huge fine. Anything we do is going to be tiny in comparison, just because we're not going to go anywhere like that. And maybe we do, in the interest of not piling on, need to go with stuff.
Say it sounds kind of reasonable to you.
I think
Okay.
it's sort of reasonable.
Okay.
I kind of looked at it as a fine per occasion, and so there were 49 total. And I was kind of thinking, okay, $500, and that kind of comes out to be about $28,000. So the $28,000 sounds pretty reasonable to me.
Well, should we wait to hear from the two individuals to see just how encouraged it was, or was this some, as in NCAA football parlance, lack of institutional control completely? And then, or did someone tell them to just do it? That's what happened.
Oh, but they said that no partners were involved. Manager, I mean, they may have just been, I don't know. It's just sad.
But she's correct. It was in Tennessee, Nashville specifically. It was manager and below, so there was no senior manager, principal partner.
Seems like to me that the firm benefited from the fact that they filled out those answers and thus they had more billable time than other firms may have. And if we don't send a strong message right here, I'm afraid some of the smaller firms may say, well, heck, go ahead and do that because it's not going to cost us much if y'all get caught. And I think that here we really need to step up and take a look at this is not acceptable, even in a CPE situation, because you're trying to get by with something so that you can bill more, get more work. And in a day that we have less employees or an issue with pipeline, it would seem like this would be more encouraged here. And so I think the board should send a strong statement, in my opinion, to state we're not going to accept that in Tennessee.
Janet, I think you were going to make a comment.
Yeah, when I was listening to this notion of piling on came into my mind, but I guess from a legal perspective, and I guess this is directed to the council, how is piling on viewed in general and or this situation?
I mean, you have the discretion to do it. It kind of comes down to what you have the ability to find more than that if you prefer to. So it's kind of how you want it to be. If you are feeling okay with adding on to what they have, or if that's something you want to steer away from, that's kind of at your discretion.
So if we want to pile on, we can have at it.
Yeah, that's your choice. Yeah. At the end of the day, I can recommend what me, Wendy, and Duke have discussed, and that's how we got to the $28,000 amount, $1,000 per reported employee. But at the end of the day, it's your discretion if you want to go higher than that, because you have the ability to.
I would like to say I think that's semi-reasonable, but I think this should be the lead story on our next balance sheet newsletter, because that's the first thing everybody looks at when the balance sheet comes out is the violations. Everybody can be, I mean, I always do, immediately go to that. I think it should be the lead on the front cover. I guess we don't necessarily mention the name, but we make an example out of them. Make sure everybody knows, because the general population is not going to know about this. I mean, CPA population. So,
I would like to ask a question of Mr. Bonner, if I may. You stated that you felt like we should send a strong message. So is 28,000 strong, or were you thinking of something?
I was kind of thinking that it should be per occurrence. So I was thinking if we have 49 happenings, it would be $1,000 per happening.
it's actually a lot more than that if you think about it. 'Cause that's just those two people.
Yeah.
I mean, it could be 100 or 200 maybe, because you got 28 employees and each one of them sending out an email or 2 or 3 or 4.
You guys give me a second. I'll give you the number that's actually sent.
I really think that this is a billing issue. I mean, these employees were earning more for the firm. They were making more. The firm was getting more. And when you sit back and look at that, it really comes down to, does this make sense? Or else you're going to have every firm in Tennessee possibly doing this, other than the fact that every firm already knows the firm that did it.
Other than the fact that the SEC fined him
that much money.
$100 million.
Yeah. So, I mean, there's other things here that are kind of keeping it from going to that level. But it just seems like our board should make a harder stance. But that's just my opinion.
If you want to give me some clarification, so there's 86 instances where answer keys were sent.
In Tennessee.
There's 51 instances.
51, will you say that again?
51 instances where answer keys were received. Somebody got it in their email box. Somebody opened it. And 86 were actually, someone took the effort to actually send it.
So what happened to the rest of them?
That's just what they provided us. I don't know if it was sent, sent out of the firm to somebody else or
that could be.
Yeah.
I'd say 86 is if we're looking at a number, because that's when you can rob a liquor store and they have no money in there, but you still robbed it. I mean, so
Are you saying there were 86 instances in Tennessee?
Yes, ma'am, that's correct.
Where one of these people, the 14 or whatever the number is, sent.
That's correct, yes.
From Tennessee.
Yes.
I mean, the 51 could be originated from another state.
That's correct.
Yes.
Is it possible that some of these participants, let's say, actually attended CPE training, and subsequent to the training, there was an examination. And I asked that because, like, we in Tennessee, we can sit through a CPA program provided by the TSCPA, for example, for 8 hours and not take an exam. So I'm wondering if some of these folks could have actually attended the training, but then the firm required submission of a test.
Was it in-house training? In-house CPE?
Yes.
Ah,
yeah, internal to
even worse.
EY.
I believe it was all in-house, correct? I mean, the entire thing is about in-house training.
Yeah, they're in-house CPE. Yeah. We have to go online to go get one. They have it just internal. It was
and then the other aspect was those that were sharing answer keys relative to the AICPA ethics exam. We do not have any of those violators that were in Tennessee.
That was not in Tennessee, yeah. So that's
But these in-house programs, were they all online programs so that, am I right that if it's online, an exam is required? If it's in person, it's not?
That's correct, yes. So it's like the typical online where you go through the program,
These
then you
were
take
all
that
online.
assessment at the end. Yeah, it was those type CPAs.
Other thoughts or commentary here?
Well, I'd like to say one more thing. I think, we started out this conversation by saying, or somebody asked, what have other states done? And I think that's a relevant question. But we have to consider that several states are going to follow us and ask, what did Tennessee do? And if we don't do enough, we're going to be encouraging other people not to do enough.
California has also issued theirs, and I don't have the details. It was over $1 million was their assessment. And again, I don't have the details in front of me, but to give you just a sense.
How many offices does California have?
I mean, they're just much
dozens.
Larger. They're just much larger than we
Right.
are. Yeah.
Right. We have, 5 offices in Tennessee, sounds like?
4.
Well, 2 in Nashville, right?
2 in Nashville, 1 in Memphis, 1 in Charlotte.
Oh, it's not one in Knoxville. Okay.
So if I inappropriately issue an audit report without a firm permit, I get fined. If I do 5 audits, am I fined 5 times per occurrence?
You can
I can be.
Mm-hmm.
I mean, I know we have a matrix. So to me, that's maybe at the heart of the question too. We have one person that does 29 and 27 and 3 and 8 and 4 and whatever, but is it per person, or do we want to somehow look at per occurrence?
You have the authority to do either. Right. Yeah.
I guess I'm just throwing that out for clarification.
Wendy, would you be able to find out how California got to this $1 million?
Also, I just looked up. California has 15 offices of this.
Well, I mean, I know that, but yeah, to get to the $1 million.
No, I understand. Someone had just asked a question how many offices there were, and I had looked it up, so I was just providing that answer since I just found it.
Okay, but no, I think Wendy was saying that she didn't have the details of the $1 million that California fined them, and I was just thinking that if we knew their assumptions and how they got to that $1 million, that might help us, as well as to, I think it was Larry who was saying other people will be looking to see what we did.
Oh, you do? Okay.
I think there's another kind of perspective here, and that is, to what degree has the firm in this particular case learned lessons from this episode, and whether we find them, 28,000 or 86,000 or some other different number. I think in light of the order that they have already agreed to with the SEC and the $100 million fine they've already paid, the question to me is, okay, is that enough for them to have learned their lesson? And based on the consent order that they signed with the SEC and the procedures, the remedial procedures that they are on the hook for, there's a piece of me that says, okay, a rational firm would have learned its lessons, as a result of that. And so that any incremental thing that we or any other state does is piling on, or could be construed as that. And I think, to me, it is reasonable to assess something. To me, $1 million is way out of bounds, but California has to make its own decisions. And we have a reasonable number on the violations that we have here in Tennessee. And I think basing it on that number, whether it be the number of employees or, John, as you were saying, the number of occurrences, that's really, to me, the decision that I'm struggling with. And but I think, if the point is to make sure that the firm knows that this was wrong, I think after writing a $100 million check, that firm knows that it was wrong badly. And it's not just that, but it's the remediation that they have to take as a firm, which is going to probably cost them several tens of millions of dollars in addition to that.
So do we know if they admitted to those charges? They admitted? Yeah,
they signed a consent order with the SEC.
Yes.
Okay. Okay.
Yeah.
And just to clarify, I got a little bit more information on California. They had 49 individuals, and they also had people that cheated on both the pre-licensure ethics exam and the continuing education exams.
Was $1.8 million.
1.8 million.
And they put the firm on probation.
For
in
24
California.
months, yes. With
So
a 30-day
they really
license
took it to
suspension
heart.
stayed during the 2 years of probation.
I think they also have to provide some sort
An
of
outreach.
training.
Yes, they have to develop an outreach campaign with topics focused on consumer protection.
Which just
Maybe we need more.
Which just so everyone knows, that creation of a continuing education course is similar to an assessment they made to another large firm for a similar situation a couple of years ago. So they're just.
Wait, say that again. In California, you're talking about?
Right. So they are requiring the firm to create an outreach program where they provide, I don't have it in front of me, continuing education course on ethics, free of charge to people, licensees to take. That is similar to a requirement they imposed on another large firm for similar
So I'm
violations.
curious, have we ever imposed fines like California hasn't fined? Did they have a history of imposing $1 million fines and we go more with the thousands? I just have never seen anything come through this board that was really large. I'm not saying it's not the time to do that, but I'm just trying to put it in perspective.
Yeah, in my time here, the recommendation that we've made is the largest fine that I recall for any violations.
For this case, the 20, whatever?
28,000.
That's the largest you've seen.
Can I ask you a question?
Yes.
From your perspective with a national firm, if we assess, and this is just opinion, if we assess 28,000, 50,000, whatever it is, would that fine be paid by the Nashville office, or would it be national office? Who's going to pay this?
Yeah, the answer is, in this case, I don't know. My speculation is we're fining the firm. In this case, it's a national firm. And so the way I would look at it is that ultimately, at the end of the day, it's going to come out of the bottom line of the owners of that firm's pockets. There will be less earnings, for the firm that would be allocated among the owners.
Wouldn't there most likely be some allocation of that to the local Nashville office, and so that they would feel it in some way by the firm?
I don't know.
I'm just asking your opinion.
I think that's a more relevant question for the $100 million fine, and whether or not that would get allocated amongst the offices. But I think at the bottom line, it was levied at the firm level to hit the owners of the firm that are responsible for managing that firm in the pocketbook where it counted. And my guess would be it certainly did that.
Well, my point is, whether we assess 28,000 or 50, our goal here is to penalize analyze what happened in Tennessee, not what happened nationwide. So you would hope that whatever we assess is assessed against the Tennessee portion of the firm, so that there's some fairness.
I really honestly don't know that we have any way of controlling that.
Oh, I know that. I know we can't control it. I'm just curious as to what really would happen. And I've never been in a national firm, so I don't know.
California placed them on probation or suspension? Which one?
So they levied a 30-day suspension, but it stayed during the 24-month probation. So it's basically if they don't have any incidences, then they won't actually be suspended, but they have to go with
I was going to say, I mean, that's got to be huge if they were actually suspended.
Yeah, it stayed, so it's kind of like if somebody was to go on probation, but they have a jail time suspended. It's kind of like that.
I mean, I think we have to, one of the issues that led to the demise of Arthur Anderson was the fact that the Justice Department filed a criminal complaint against the firm and not the partners. And in certain states, such as California and Texas, that the filing of that complaint effectively meant that they had to immediately cease doing business, and the firm collapsed like a house of cards. And that's. I just don't think we have any case to be going anywhere near there to warrant that kind of a discipline. In my view, if this PCOB SEC order didn't hit them upside the head with the 2x4, nothing that we do will. And so, I'm not one for bayoneting the wounded after the war is over here. That's kind of where I'm coming out. So I think there needs to be some fine. I don't think it needs to be egregious. I don't think we can control how it would be allocated to the local offices here. But it's, clearly they admitted in the SEC order that they consented to that they had, done some inappropriate, that their folks had done some inappropriate things and that they did not appropriately manage that situation. And they're going to, my belief is that having seen other SEC orders imposed against national firms, that the SEC generally makes sure that the remedial actions get done.
I was going to say they've already, through their dealings with the SEC and their own, I guess, actions, they've already revamped what they're doing, supposedly. So normally I would think we would have all sorts of requirements like that, which would cost them a lot of money, but there's no need to do that because it's been done.
I agree.
I guess I don't generally like the notion of piling on as I understand it. I guess I wouldn't be opposed to some additional fine or fining with the Tennessee offices, but generally, I guess I don't think I like that notion of doing that, piling on.
You don't like piling on, or you don't like using that as a reason?
I don't like piling on, and it seems like when we've had other cases that the SEC or some other national body has been involved with, and maybe it wasn't necessary for us to try to do something locally, but it seems like we generally went with whatever the discipline was at the national level, and that was it. So I guess what I'm saying is that it seems like it would be consistent to just go with what the SEC has done and not necessarily even pile on. That's my opinion.
Thank you, Janet. Any kind of further discussion? Then I'll try to crystallize the options on this segment of it that I think we have before us here.
I just have one last question. If an individual had done this, not the big firm, but an individual had cheated on CPE and we knew about it somehow, how would we find them?
So a couple of things. I think you're going to see that in another entry on your legal report. You're going to have, there is a CPE violation in there. I think a lot of times what we do is we try to make the penalties mean something to the individual or the firm as it may be, I don't think we would fine an individual $28,000 if that's kind of what you're. But we have certainly fined for CPE violations. It has typically been around $1,000, which then equates to the recommendation. I never really thought of it that way, but to this equates to this equaling it out because we took it $1,000 per individual. But
I think that sounds reasonable to me then, the 28. That's just my opinion.
Maybe just kind of to review the situation on this subtopic here. So we have council recommendation for a $28,000 fine, which is basically based on a per individual, not per instance or occurrence. That's out there as council's recommendation. We have a sentiment on part of some board members for zero, in other words, no additional incremental fine from the piling on perspective. And I think there was a possible scenario where I think the investigator represented we had 86 instances of violations. So we could fine on the basis of the number of violations as well. I think the other thing that we need to be mindful of is that we can attempt to fine all we want, but the firm has a right to respond and to defend itself. And we also, I think, have to consider the costs in terms of that and staff time and legal time as we go through that as well. So I guess where I would come down for consideration is I'd recommend that we go with council's recommendation on this in terms of the fine. And then we're going to address the individual situation in a separate discussion here in just a few minutes. But for the committee members, I guess maybe it'd be helpful to just get your sense of where y'all are at on that, and then for the other board members who are not on the committee.
I'm looking at our matrix, and where we don't satisfy CPE, it seems like our penalties have been $500 to $1,000 per instance. I'm vacillating between, do we do it by the number of people or do we do it by the number of occurrences? And because we just can't have this, an attempt to have this happen also. But I think the dollar amount per seems pretty reasonable. It's just a matter of people or occurrences. I don't know, but I don't think zero is the answer.
I would.
Well, this is Janet, and I guess like I said, don't think it would be helpful or as helpful as maybe given what maybe we're trying to accomplish to pile on, but I would be very clear in our decision if we were to do nothing that it's because of what the SEC has already implemented and required. I wouldn't just do nothing in the situation, but I would make it very clear that because of what the SEC has already required, that, well, my belief anyway, is that would be sufficient, particularly because we can't really tell where any discipline that we might give, if it will really hit Tennessee officers or not, or individuals.
Thank you, Janet.
Mm-hmm.
Mr. Chairman, I don't think it should be nothing. I could go with the $28, $1,000 each, or I really think occurrences for open email, which would imply that somebody opened up and looked at the answers, that $1,000 per open email or occurrence would be more appropriate, and not sent, since we can't verify whether we're open or not.
Just correct you. The actual times they sent is 86. So to me, you can't control who sends you something,
right.
But you can control when you push the send button. Here's an answer key.
Yeah.
And so I think that's where it's the 86.
Okay. Well, what you actually said in that there was 50 something,
51.
51 that they
that
actually
opened
received it. Well, they received
Okay.
it. It was in their email, but
Okay.
I don't think we have clarification if they
No.
opened it, used it,
Okay.
so forth. But we know for sure 86 people sent it. So I think that's more of a concrete number as opposed to the 51.
28 people.
Okay.
28 people with 86. 28 people sent it, right?
14.
14.
Oh,
sent the
14
86.
sent
Yes.
it.
There's
Yes, I'm
that.
sorry.
86.
Incidences.
Yeah, there's that
86
other
incidences.
universe that knew about it but didn't report
Okay,
it. That's
I'm sorry.
that.
Okay.
I apologize. 86 incidences of being sent.
I think 86 instances is the answer for me, but that's just my personal opinion. I think a strong message needs to be sent by this board because they may not be doing SEC work. A firm may not. And so we need to make sure that if anybody's doing this in our state, that they get the message that violation of ethics in this way will not be tolerated.
Maybe it doesn't matter, but is the 86 the number of emails or the number of recipients? Could it have been one email with 86? You know what I mean?
That's a good question. In talking with the attorney, they're able to, yes, every time it was sent. It doesn't have how many people received it. It's just how many
So
times.
it's at least 86.
It's at
people
least
it was sent
86.
to.
That's correct.
Oh, 86 could have gone to 50 people.
That's correct.
86 times 50.
Yes. Yes. They just hit send.
Okay.
Yep.
But we don't have that information. Just to clarify.
And so, and we're provided this by the firm's attorney.
Correct.
Okay. And have y'all looked at what they did sign? Did they admit? I mean, I asked that before, but are we 100% sure that they admitted to the cheating?
The employees or the firm?
Either.
Okay,
Or.
so I know the firm did through the
Okay.
consent order.
Okay. And it said that they admitted because I'm not seeing where they admitted it. I mean, they're taking the penalties and they're agreeing to pay they're agreeing with the consent order, but it doesn't.
In the signing of the consent order, they're agreeing to the facts in terms laid out within it. So let's just say, for instance, in my consent order, I asserted a fact that this email was sent 86 times, and they sign it. That's in them within the eyes of the law agreeing to that statement of the facts. And then
If there's a line in there that says we neither.
if that's in there, that could be argued differently.
Do we know? I mean, I'm just asking. Do we know the answer to that?
That's something that we would put in our consent order. Typically.
Okay. I just want to know.
And it could-
Are they admitting fault? Because to me, that is important with respect to have they learned their lesson. If they're neither denying or admitting, then that tells me maybe we don't really.
Just
you
one
know.
moment. He's pulling up the consent order.
Yeah.
Because it's in a consent order, it's not appealable, right? So the $100 million is going to be paid.
That's correct.
Oh yeah, I'm not saying that.
Yeah,
Nothing
and
about
that
the
would be
money.
at the SEC's discretion if they included that line in there because they're the ones writing. Their counsel are the ones writing the consent order. So I don't foresee them putting that in there in this kind of situation, but he's double checking.
I have another question for our board chairman, not the committee chair, but the 86 instances that you think said we should penalize for, is that at 1,000 per instance or maybe 500 per instance?
Out of bounds that it should be 1,000. I mean, because there was definitely a motivation to keep their people in the field and working more instead of taking the time to go through and do the exams. And so there's another side of this that just kind of comes out in my mind that it was really revenue and workload related. And that's where I come back to say, well, the penalty needs to fit the crime, and the crime is that, and crime's a bad word, but the violation of ethics.
Okay.
But it needs to fit exactly what was going on. And in this case, we don't know how many people took advantage of this once they got the answer. We just know that 86 times it was message. Like to me that look at what other states are going to do. This is going to be very small compared to other states. And I'm not worried about what other states are doing. And I don't think the firm at all the firm has already agreed. I don't believe in the probation. I don't want to go anywhere there, but I do think that when you
I don't want to put the cart before the horse, but it seems like recommendation number 3 is intertwined with number 2 here, because you have 2 people who sent 49 times and the other 12 sent 37. And so if you're going to go with occurrences in 86, what are you going to do in number 3 here? That, do we go after those 2 people separately somehow? I don't know. They just feels like they were the primary culprits and it's still on the table. Are we going to do something separate with them?
Yeah, so right now what is being proposed is discipline at the firm level based on the firm permits, in essence, that of the 2 offices that had violators in them. So the second topic for us to discuss is whether or not to consider opening up a complaint against these 2 individuals. And we will have that discussion, but I agree, it begs the question of what if any discipline would need to be imposed relative to them if a complaint is opened and ultimately discipline is imposed. So it seems to me that there is a consensus based on the feedback that I've heard of going ahead and imposing some level of fine, and that there are some folks that are comfortable with the $28,000, which is based on, I guess, the number of people involved that have been represented to us. And then there is also a sentiment for going ahead and fining on a per violation basis based on what we know about the number of times the answer keys were sent. And at $1,000, that would be $86,000. So it's really, we're looking at an $86,000 range under that scenario and a $28,000 range under the other scenario based on number of people.
I'm not firmly set on the 28. I mean, the incidence bothers me, so I could go that. I could go to that level too. It's difficult, but I could go with the 86 as well, times some number.
Mr. Chairman, I would consider or ask us to consider considering the 86 instances, but we don't know that a violation occurred in every one of those. So I might drop the penalty to $500 per incidence for the 86 and make that a $43,000 penalty. That's not a motion yet. That's just
okay
to try to get us to come to a number.
I was thinking.
Well, does the 86 instances relate to people the answer keys being sent out 86 times?
Correct.
Yes.
So that is a violation. It's cheating to send out answer keys.
And we don't know how many people received. Well, we know 51 received, but we don't know how many people used it or how many people they actually sent it to. Right? It could have been many more than 86, as we said.
Right, but it's still, it's cheating if we know for sure the answer keys were sent out 86 times. That's cheating.
I like Greg's idea, and it comes close to 2,000 times the 28 employees. I mean, it's not exact, but I think that's a good
middle ground. Mm-hmm. Okay.
Can you say that again, Pam?
I like the idea of 500 per incident, so 500 times 86.
I thought I heard something different. Okay.
Mm-hmm.
So that would be a $43,000 fine that would be recommended. I would say let's just go ahead and kind of, at least from the committee perspective, call the question on that. And so is someone willing to state that, Greg or Gay, in the form of a motion?
Mr. Chairman, I would make a motion that we assess a civil penalty in the amount of $43,000 for the violations.
Okay. And is there a second?
I'll second.
We have a motion and a second. Any further discussion? All right, we'll go ahead and call the roll on that. Karen?
Evan Monroe,
Aye.
Greg Gilbert,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
Motion passes in committee, and then we'll deal with this at the board level tomorrow. The second issue that is part of the council's original recommendation is for the board to determine whether or not to open separate complaints against the two employees who stood out relative to the number of occasions in which they sent answer keys, one being 22 occasions, the other being 27 occasions. Now, by way of background, I think, Duke, you indicated at least that one of the employees was no longer employed at the firm.
That's correct, yes.
Do we know that? Does that presume then that the other person still is employed
They're still
by the
employed
firm?
there, yes.
Okay. All right. Was there any additional information on those two individuals that would be relevant to our consideration that you were given from council?
Yeah, so the one that's still there was punished internally. I just looked up their punishment if you want me to read it to you.
Now that would be relevant.
Yeah,
At what level? Are they both manager?
No. The one that left was a manager. The one that's still there is staff.
Quick question, just so I understand. Why would it matter if they're gone? I mean, this is on an individual basis, right?
Yeah, I think it is on an individual basis is what we're talking about.
I'm
now.
not talking about the firm.
And,
I'm talking about on an individual.
You know, I'm not sure that it necessarily should if they're still holding out as a CPA in
Right.
whatever
I mean,
venue they're
that
at.
concerns me even more in some ways.
Were they fired? You know?
No, they
I thought I
resigned.
heard somebody.
They resigned. I guess the only difference would be is if someone punished internally already. I don't know if that, but there's no indication they were ever disciplined for any of this while at the firm.
But it also doesn't mean that they could take another job in another state.
That's correct.
And use their CPA license. And I mean, I don't know. I mean, I think we've got to consider a lot of different avenues here of what could potentially happen.
We know that the
choose
two.
to do or not to do.
Sorry,
Go
thought you were
ahead. Yeah.
finished.
No, I'm done.
Do we know that the two individuals were licensed? Both.
They both were, yes.
Okay.
I sound like I'm digging too far, but the SEC said that this firm encouraged and facilitated these actions. So how can they punish someone if the firm created the environment and did the firm dictate? You know what I'm saying? I'm curious, would we know if there were any other lawsuits of someone suing and saying, wait a minute, I did this, but my supervisors told me to do it?
I'm not aware of any. I looked stuff up like that to see what would happen. I guess, you know, all these partnerships are going to be different throughout the country and how things operate in some ways. This one, at least with here in Tennessee, specifically to the Nashville office, this is kind of specific to Nashville. While it's good it wasn't, you know, senior manager above, there is concerns, what kind of supervision was being done on the lower staff level, and then two, to be early in your career doing this is somewhat disconcerting because you can see that these are all fairly newer employees.
Well, we're not going to know unless we ask them. So.
And didn't we, I mean, okay, so how long did this go on? Was this just
from 2017 to 2020?
Okay.
Getting ready to tell us what the firm did internally to these people.
Yeah, so it was a variety of punch. So at a base level, everyone had to, you know, reaffirm the firm's code of conduct. And then depending on the level you're at, financial penalty, sometimes a promotion was withheld. In some instances, some people may have been demoted. Now, what's kind of more difficult to determine is that's also what other issues an employee may have had within the firm that could have caused the penalty to be a little bit more than what someone else who might have had the same type of behavior, but they didn't want to get into that for obvious reasons.
We need to consider, I mean, we've got two people that were blatant in doing this, but we had 86 emails that went out So that means there were more than just two people, because between those two people, 49 of that 86, or I think that's my math, involved. So do we need to look at the other individuals that sent out emails with answers?
I think we just specifically cut out these two, or more than triple any other employee identified. So I think based off our discussion, we had just kind of decided that the firm's discipline kind of included enough for the other ones, and these two were way more egregious than the other ones, and that's why we put these two out there.
I think initially our thought was to not involve the employees. But then when we started to talk about it, we thought it was fair to tell you all that there were two that were more egregious than the others, and then let you all decide if you felt like we needed to bring those individuals in under separate complaints.
So the other employees that may have been involved just had one or two sharings, and they've probably heard.
Yeah, the next highest number after 22 was 7.
Yeah, so these two were much higher than the other ones, and that's kind of why we cut them out. We did initially speak and decide we would kind of be going into a rabbit hole to pull out every single employee that was involved, as opposed to doing it at the firm level. But these two were more egregious than the others, and so that's why their information was provided.
Would it be appropriate or inappropriate for us to, as a board, I mean, I just think understanding some of these nuances about it might be helpful for us to read the consent, or is that wrong? Or
I mean, the SEC consent order is a matter of public record. I've got a hard copy of it with me.
Okay.
Technically, these are supposed to be anonymous, so
but the SEC made it. Yeah.
No, but our complaints are supposed to be anonymous, so we cannot clarify
or deny.
Cannot confirm or deny who these complaints are against. If you feel that you believe you know who it's against and you do your own research, I can't control what you do, but we cannot provide you any signed documentation or anything like that that's indicating who the respondent is, because this is an anonymous complaint.
Okay, gotcha. Thank you.
So, sort of rhetorically, if we were to take out a complaint against these two individuals, should we wait to hear what they have to say before we implement the fine? Because they may say, "Oh, we were told to do it. We got a memo that said do it." You know, no telling what they might say.
In my mind, I think there's enough. I think the first vote that we took essentially as a committee was to hold the firm accountable for its actions. And I think that, to me, is separate and apart from the individuals who press the button 22 and 27 times. Now, they have a right to defend themselves individually if a complaint is opened.
Well, I would say maybe it should be more than what we're doing. If they were just told to do it, flat out said, you do it, and they were made to do it as part of their employment, let's put it that way, should the fine be more?
So where are we with these two individuals? You said, should we wait until we hear from them?
You mean as an open a complaint and investigate specifically the two individuals?
To see what they have to say about it, right.
I think what he's saying is maybe wait on the firm.
Right.
Is that what you're saying?
I'm sorry. Yes,
like
I was
hold
being
on the
unclear.
decision for the
firm.
firm.
Is he saying when he says speak with them? Does he mean like investigate and have conversations with them before we vote on anything pertaining to this complaint?
It was just an idea.
I'm just trying to clarify that.
That's what I was saying. Yes.
Did counsel say that this complaint is anonymous? Did I understand you to say that?
Well, all complaints are anonymous, so.
Oh.
Supposed to be presented to you anonymously. So we know you're not supposed to know who the complainant or the respondent is.
So in this case that we're talking about against the firm, who is the complainant?
Who filed the complaint?
Yeah.
This was a board open complaint, so you
could.
But yeah, typically in general, you shouldn't know who aside from board open complaints, you shouldn't know who the complainant is or the respondent. In order to avoid bias, we present them to you anonymously. That's why you don't have any names within them. If you read the information and you determine who the respondent is, that's on your own accord, but we're not supposed to provide any information. Typically, you would recuse yourself if you had any involvement or knew any information, but this is everybody on the board would have to recuse themselves, so this is an untypical situation. But yes, typically it's anonymous.
Normally, file complaints against individuals within a firm if those individuals did something in violation of their?
I view we would, or at least we'd consider it, yeah.
I think we should go ahead and consider these and assess the fines and let them come back and tell us if we're wrong. You know, then they can come back and give information. It seems that the information we have before us says they did something pretty bad.
I guess the question is, do you feel like we have investigated these two people enough to know what really happened in the firm? Were they told? Were they not told? I know the firm has entered into a consent order and said it happened, but would that have a bearing on what you would bring, or and staff and attorney would bring back to us to say that this was in such a manner that maybe you should consider more? In other words, if we settled with the firm and then we went and investigated the other two, because I don't know if we haven't given them a chance to say what their side of the story is, have we?
The employees know. No.
And so we wouldn't bring, in a normal situation, we wouldn't bring this to the board until we had actually investigated it and talked to the individuals involved. And so that's the question.
But because no complaint's been filed against them?
That's correct, because it was just a complaint against the actual four entities, not the individual employees.
But investigating the firm, we found out that, hey, this was out of the ordinary.
That's correct.
Whether or not their supervisors told them to do it does not really affect whether they're wrong or not, because according to your license, you can't. That is an excuse. But I do agree with your point that if they were told this from above, then we should be perhaps considering other individuals and stronger fines against the firm. But I don't know if we want to go there. But I guess my bottom line is, I guess I would say we should open complaints against these two individuals, is what I would say.
We can open complaints. An investigation can be conducted. They can speak with them. I will provide you, Neil or I will provide you the information at the next meeting, and then you can make your decision on how you want to proceed with them at that time. It could be, you could hear what they have to say and you could think, oh, I don't want to discipline them. You could hear what they have to say and think, I would like to discipline them individually. Once we provide more information.
Depending on what they say, can we revisit the firm fine?
You would have to open a secondary complaint.
Wendy, from your perspective, do you believe that you need specific board approval to open up a board complaint relative to these two individuals, or is that something that can be done on your authority?
Oh, no, it can be done on my authority. I believe the reason it's before you is because we were not going to open complaints.
Okay.
Against the individuals.
Yes.
But I was uncomfortable with you not knowing about these couple of egregious type matters. So.
Okay. Well, from a committee perspective, I'm kind of hearing that there's a consensus that there's a willingness to go ahead and open up complaints against the two individuals that were seemingly more egregious in their number of times they sent answer keys. Is that a consensus among the committee members?
The individual that's not there anymore, are they are they still in Tennessee practicing?
According to the information we have on
the they still maintain a Tennessee license, yes.
I mean, I think opening up the complaint is advisable, and it may be that having Duke sit across the table from them and asking them questions may put the fear of God, and that may be all it needs based on their responses. But I kind of think they need to have a little chat.
Other committee members, do you have a sense of that?
I agree with that.
Okay. Well, as chair, I'll put forward a motion that we go ahead and authorize staff to open up complaints relative to the two individuals who, as listed here, stood out as a possible concern due to the number of answer keys that they sent. Is there a second?
Second.
Is there any further discussion?
Can I ask just a clarification? I'm not on the committee, but could we postpone can it be postponed to vote on the firm decision until after we've learned more about the individuals and move forward from there? Or no? I mean, I'm just wondering.
I mean, I think in theory it certainly could be if the board wanted to do that. Now,
Yeah.
The committee has voted to go ahead and impose the fine, and tomorrow we can revisit that as a full board. But in theory, that's possible. I personally differentiate the firm situation from these individual situations, so I'm not uncomfortable proceeding independently with those. So I think we have a motion and a second relative to the two individuals and opening up complaints against them. Any further comment or discussion? Karen, will you call the roll?
Monroe,
Aye.
Greg Gilbert,
Aye.
Gay Moon,
Aye.
Rob Vance,
Aye.
Motion passes. We'll go ahead and we just have a few more cases. Mr. Chairman, do you want us to take a break now, or would you like to go ahead and continue?
I think take a quick 15-minute break or 10-minute break, and then yes.
Okay.
All right, we're back, and we're still in enforcement, and I'm going to turn it back over to our chair, Kevin Monroe.
Thank you, Mr. Chairman. We have 4 more cases. We have 4 more cases with proposed discipline to go through. Item 12, case number 2022051351, relates to failure to renew a firm permit, operating without a valid firm permit, and then advertising a test services without a valid permit or signing up for peer review. In this case, the respondent's firm permit was due for renewal on December 31 of 2018, but it was not renewed at that time and subsequently expired after the 6-month renewal grace period. Nevertheless, respondent's firm appeared to continue operating and listing compilations among the offered services, which isn't a test service requiring a firm permit and compliance with peer review. Accordingly, the complaint was opened. The respondent states that they have since renewed their firm permit and explains they were unaware the permit had expired until they received this complaint. In response to the listing of compilations as a service on their website, respondent states their site is based on a template they purchased. They were not aware their site listed compilations as a service until the complaint. They apologize for not doing a thorough job reviewing the services that came pre-populated within the website template they purchased. They state they would take that option off their website. The investigator confirmed respondent's website no longer lists compilations as a service they offer, and there is no evidence that the firm has provided any customer compilation services. However, based on the information available in respondent statements, the firm did operate without an active permit for around 2.5 years. Operating a firm without a valid permit violates board rules, and as a mitigating factor in this case is that the respondent quickly remedied their expired permit once informed of the complaint. The permit was placed in active status in January of 2023. Council recommends assessing a civil penalty of $500. Is there any comment or discussion on this case? Larry?
I'm a little bit confused. So they had a firm permit expired, and they didn't mean to say they were doing compilations, but they did. And then they renewed the firm permit when they were told that they should have. So are they saying, are we saying that the $500 fine is for saying you did compilations, or is it for not having the firm permit?
I think it could be for either, but basically for continuing to operate as a firm without a firm permit.
So it's $500. I don't want to get into this discussion again about is it enough, but I'm a firm believer that in this one and also another one down the road here, that if we don't make assessments strong enough, that people will look at the potential penalty and say, well, that's worth the risk of not doing what I need to do. So my question is $500 what we would normally do in this case, given the fact that there were two things they were doing wrong?
I mean, I think there's a history where we may have given a letter warning because of quick remediation and no proof that anyone was harmed. But in this situation, I think we felt like it had gone on for a long period of time, and there were a couple of different things there that were falling outside of the requirements. So we felt like a civil penalty might be appropriate in this situation.
I agree one's appropriate. I'm just asking, is this enough? Since there were two potential violations.
Yeah. Now, to clarify, their website said they offered compilation services because they were using a template that said that. But I think it's saying there is no evidence that the firm ever did provide any customer compilation services.
Really, the penalty not having the permit.
That's kind of how I'm leaning that way, because they didn't really provide a service that would have required them to have a peer review. But their website template said they offered those services in a public way, and then when that was brought to their attention, they corrected it. That's kind of how I got comfortable that this is really primarily for an expired permit.
Yeah, and that was kind of the mitigating factors that we looked at, and then they did go quite some time without it, and that's where we got the fine from. But once we spoke with them, I believe they were pretty timely in updating it, and they said it's just kind of something that...
This $500, according to our template, is that the normal?
That's with mitigating factors, so that's what that was based on. So there's a 3-prong layout. If there's mitigating factors, is a typical fine, which would be $500. If it's just no mitigating or aggravating factors, I'd have to pull up and tell you what that was, but there's a fine amount. And if there's aggravating factors, we have a fine amount. So this was based on mitigating factors of they never actually provided any of those services, and then their quick response to remedy the expired permit. I can look and see what the typical without mitigating is in one moment and just let you know.
I think they just failed to look at what they put on their website. They just cookie cuttered basically an accounting firm website, and they said they were offering these services, but they really didn't offer the services. Is that right?
I'm fine with that. I'm just talking about, they went 2.5 years without a permit.
Well, I should know the answer to this question, but or I guess this statement. So if you're not providing any attest services, do you need a firm permit? Because they're saying they weren't doing compilations. If you're not doing compilations, you're not doing reviews or audits either, right? So do they need a firm permit?
This firm uses CPA in their firm name. So yes, it's required to have a permit.
Got it.
Any other questions or comments?
I have a question. Wendy, the firm permit was due for renewal December 31st, 18. So what kind of correspondence would they have received? I've just forgotten. Do they get a notice that your firm permit is expiring, and then your firm permit has not expired? And so really the question ends up being, did they just ignore all of that?
Yeah, so when the renewals go live, they get a letter in the mail. Now they get a postcard. At that time, they may have gotten a letter. So around the 1st of November, they get a letter. We also email them, typically sometime in November, and then we'll do some follow-up email reminders, and then they'll get a second letter once that late fee's been assessed at the end of January. So all in all, they get 2 letters and a variety of emails.
So they were not responsive until a complaint was open?
Correct.
Yeah.
And typically without thinking of any mitigating factors, it would be a $750 fine. $750.
Mitigating by, you mean mitigating that helps them or hurts them?
It helps. So that's how we got to $500, which was...
But you also got the other direction where they ignored
aggravating, yes, which would be $1,000 typically.
See, I think it's 1,000. It should be 1,000 because of all the things that Wendy just said that they ignored.
And if you were to not consider any mitigating or aggravating factors, the typical fine violation would be $750.
I'm on the committee. I would recommend 1,000.
Other comments or thoughts?
Well, this is Janet. I'm not on the committee either, but I do know that there are quite a few firms who use templates to design their websites. And some of those designs do include just generic pages that a lot of CPAs services might include, but not all. So I guess I could see how this could happen. And if you don't offer attest services, I think, Wendy, you said because there's CPA in the name, that's why they had needed the firm permit. I think on number 8, I don't know if there was CPA in that name. I know I'm going back to a previous thing. And Wendy, you can easily answer that if it was, because they only offer tax services. So I guess I could just see how that could happen, and I'll just put that out there for information.
Thank you, Janet.
So, just to clarify, on number 8, this was a new licensee to Tennessee. The individual, I did go back and research. The licensee, when they obtained their reciprocal license in Tennessee, they did contact the office multiple times. I can't listen to the recordings because they're not available anymore. But the individual said, I reached out trying to understand what kind of permitting I needed. So we felt like she had attempted to do what she was supposed to do, and what she wasn't offering any attest work. And in number 8, they are using accounting in the name, so they're required to have a permit, and quickly turned around and got the permit. In the case that we're talking about right now, this is an individual that was permitted. They knew they should have been permitted and didn't renew the permit. So those are the differences, I believe, between the two.
Thank you, Wendy. Other questions or comments? So the council.
I would just say, in terms of this template thing, as I know in my profession, you got to know what's on your website. You need to know what's on your website, and if they got compilation on there, I don't think that's an excuse that they used a template. But that's just my perspective of it.
So the council's recommendation for this one is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $500. Is there a motion from a member of the committee with respect to our recommendation, including an appropriate fine amount here?
Mr. Chairman, I agree with the recommendation and would make a motion that we approve that. However, I would change the penalty to $500 to $1,000 from $500 to $1,000, simply because it appears to me that they were notified probably several times around the time the firm permit expired, and just shortly subsequent to that expiration, and no response. So I would agree with the recommendation, but we change the civil penalty to $1,000.
Okay, thank you. We have that motion on the floor. Is there a second?
I'll second.
We have a second. Any further discussion? Karen, will you call the roll?
Evan Monroe.
Aye.
Greg Gilbert.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Motion passed. We'll proceed to item number 13, which is case number 2022-051-961. This is a case relating to lack of due care and a potential independence violation. In this case, the Tennessee Board for Licensing Contractors received an independent auditor's report by respondent on behalf of an application by a Tennessee construction corporation. The respondent has a CPA license in Tennessee and Mississippi, but the business they work for does not appear to hold a firm permit, nor are they enrolled in a peer review program. The respondent stated that they work part-time.
Janet Booker Davis
is now exiting.
Respondent stated that they work part-time and that the company they work for does bookkeeping work, payroll, and tax returns. He explains that they do not work for a CPA firm. He states rather they only prepare tax returns and help clients through IRS audits, but asserts that they do not perform audits or prepare financial statements. Respondent states in the case, however, that the company they work for was trying to help one of their clients with a startup construction company, and the related construction business was not conducting any activity at the time, and the only financial transaction was the opening of a business checking account with an initial deposit. Respondent states that they only completed a balance sheet with that initial deposit and corresponding shareholders' equity, and that there were no other financial transactions. Respondent states that their employer was trying to save the client the expense of a certified audit since, quote, there wasn't anything to audit, end quote. Respondent states, as such, they agreed to sign the auditor's report, and at the time they did not know it had to be completed by a Tennessee CPA firm. An investigation was conducted. When the investigator questioned the respondent as to why they provided a report on financial statements that they did not complete an audit, he answered that a secretary at their office typed up the report based on internet research, and the respondent just subsequently agreed to sign the report. The respondent expressed remorse for their mistakes and explained they are only a part-time employee that was just trying to help their employer and a client, and that they were compliant in the investigation. And, well, respondent was compliant in the investigation and provided the requested documents to the investigator. Essentially, the violation here is that we have a violation in terms of the AICPA rule regarding self-review threat, the threat that a member will not appropriately evaluate the results of a previous judgment made. In this case, the respondent violated several rules when they created the financial statements for the client and then provided an audit report for the client. While the respondent asserts that they did not actually complete an audit for the client, they provided an audit report advising that they did complete one and were bound by the standards of independence. Based on the aforementioned violation, counsel recommends assessing a $1,000 civil penalty. That total is based on a $500 penalty for violation of the AICPA Rule 1.210.017 and a $500 penalty for their violation of Tennessee Board Rule 0020-03-07, which relates to exercising due professional care in the performance of professional services. A secondary complaint was subsequently opened on the firm that the respondent works for, and so that the firm permit and peer review issues may be investigated further at the firm level. So the recommendation is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $1,000. Any comments or questions on this one? Gary?
Kevin, or Mr. Chairman.
Either way works with me.
I would say, I mean, this is an audit. This is not a compilation or review. And typically our consideration of issues increases in severity when we're talking about an audit. I mean, this guy or this person has admitted.
Janet Booker Davis.
This person has admitted that they knew they didn't do an audit, but they signed an audit report.
Is now joining.
And I think, here again, I don't want to appear to be on a wagon today of going up on the penalties. I just think this is a bigger violation than what a $500 penalty would be for. I mean, not understanding what are the mitigating factors. I didn't see anything good in here and there's mitigating factors that I don't see. Well, 500 for each. But you said that you went on that.
Yeah, I think this was just based on speaking with the respondent and kind of he did it, to my understanding, which correct me if I'm wrong, he kind of did it at the direction of his company to help a client.
Makes it worse. And help.
Yeah,
Well, I think that makes it worse for the firm.
There's a number of issues here. The respondent is a retiree, does this part-time, and it was very remorseful when I talked to them. Acknowledged that they knew what they did was wrong. His first question is, how hard is the board going to hit me? And I said, well, that's not my job. I collect facts. That's not
under my purview, I said, but cooperation is expected and hoped. And immediately signed an affidavit in terms of supporting what he did was wrong, and that's, to me, I guess, the mitigating factors is the cooperation after the complaint.
But but knowingly, it's one thing to sign an audit report that might have been wrong, but you did it based on you thought it was right, but it turned out to be wrong. In this case, he did it. It's almost like premeditated. He knew it was wrong before he did it.
Yeah, I mean, you're right. The facts are pretty, overwhelming. He actually signed an auditor's report and admitted he didn't do an audit. I mean, and I understand it was a single transaction financial statement, but still.
And for that part of the penalty, we're going to charge him $500.
Well, you're open to discuss a higher penalty. That's just something that the three of us had discussed in our recommendation.
I'm just talking to everybody.
No. Yeah, I'm just saying. But I'm totally open to a higher fine. That's just kind of something that, based on what we had discussed in his conversation with the respondent, that's just what we landed on. But I mean, I'm totally open and supportive of a higher fine.
I think it's worse when you go into something knowing it's wrong and you still do
it. Did he know it was egregiously wrong what he was doing, or did he know it was wrong after you told him it was wrong?
He knew it was wrong after I told him it was wrong. Yeah. I don't think he has any public practice. I think this respondent has been in government service for majority of their career.
So, I mean, is the purpose of our fine deterrence? I don't think this guy's ever going to do that again.
That's kind of the vibe we got from him, and that's what we got on our discussion.
I mean, he's never going to do anything like that.
Yeah.
I mean,
very remorseful. I think he deeply regrets it. I think this is a part-time job that he was not intending to turn into over a multiple $1,000 fines.
This says respondent signed an auditor's report despite knowing no audit had been conducted.
That's correct.
That's not saying he did it, but you just now said that he knew it after you told him it was wrong.
More so, I think the fact that he didn't realize he was committing such.
He didn't realize the gravity of what he did until the complaint came in and I called him. He knew it was wrong. That's exactly right. He knew signing something that says I conducted an audit. He knew that was wrong. I don't think he knew the level it was until I talked to him.
Sounds like we need to send him to some CPE.
A lot of it, yeah.
Is he of the retired variety? I mean, he still needs CPE, right? I mean, his license is still active, right? Okay, all right.
He's in his mid-70s, and he's doing a part-time job, just doing tax returns, and I think it was, hey, can you help us out with one of our clients? And it turned into this.
All that is irrelevant.
It's mitigating factors that the board can consider.
I think it's
you don't have to, but it's just information.
It's aggravating factors. It's not mitigating. Okay. To know it was wrong.
Yeah, you could discuss that. Yeah.
Thank you. Other comments or questions?
Just curious, did he issue the audit report in his name only or in the name of the company he worked for?
The letterhead was in the company name, but he signed it individually.
Other comments or questions? Okay, so council's recommendation is authorizing a formal hearing with authority to settle consent order upon the respondent's payment of a civil penalty in the amount of $1,000. Is there a motion from a committee member relative to this proposed discipline?
So moved.
We have a motion. Is there a second?
A second.
We have a motion and a second. Is there any further comment or discussion? Aaron, will you please call the roll?
Evan Monroe.
Aye.
Greg Gilbert.
Aye.
Aye.
Bob Vance.
Aye.
Thank you. That motion passes. We'll proceed to item 14, which is case number 2022-040791. This essentially is a case about lack of due care and lack of communicating of tax due to client. The complainant states that the respondent filed their federal taxes for several years and was set to file their 2020 work as well. Complainant states that they uploaded all the required documentation to the respondent prior to the filing deadline. Complainant states, however, on May 4th of 2021, Respondent informed them that they would have to file for an extension because they were unaware of how to handle the small amount of crypto coin transactions the complainant reported. Complainant states respondent failed to inform them that they owed the IRS $4,000 and ignored the complainant's attempt to reach out to them. Complainant states respondent did not contact them again until October 12th of 2021, when they were sent a worksheet for the depreciation of the rental home. Complainant says during that conversation there was no mention of the taxes complainant owed to the IRS at that time, and they are now facing potentially significant penalties once they file their 2020 return due to respondents' mistakes. Respondent states they didn't have any issues completing the complainant's taxes previously, even when they received complainant's information last minute in the past. However, with the complainant's 2020 taxes, the complainant did not upload all the required documents until May 10th of 2021, with a then filing date of May 17th, 2021. Respondent states they did not file for an extension until May 17, 2021, after receiving all of the complainant's documentation, and that they understood they should have been in better contact with the complainant. However, their spouse was diagnosed with a life-changing autoimmune disease around the time of the filing, and they were dealing with multiple different doctor appointments and tests during this time, which caused the unusual delay. The respondent states they were additionally overwhelmed trying to learn and comply with the changing laws surrounding cryptocurrency. And in hindsight, they realized they should have suggested complainant find another preparer to conduct their return when they didn't receive the complainant's documentation until days before the filing deadline. And there's also a dispute. The respondent states based on their information, complainant only owed $2,600 to the IRS, not the $4,000 amount alleged. The respondent informed the investigator that their normal practice is to advise clients when an extension is filed. Payment of taxes due even though an extension may be granted. Respondent noted, however, due to their spouse's health problems, they do not have a specific recollection of if they advised complainant in this instance of the requirement to pay the estimated taxes due. Under the rules of the Tennessee Board and the AICPA, due care requires a member to discharge professional responsibilities with competence and diligence to the best of a member's ability. When respondent failed to advise complainant that there was an outstanding estimated tax due and owing, even though an extension is or reasonably expected to be filed, the respondent violated both of the rules. Due to respondent having no previous history of any discipline in their almost 40 years of practice, as well as the mitigating factor of the respondent's spouse's serious health issues at the time, counsel recommends assessing a civil penalty of $500. So the formal recommendation is to authorize a formal hearing with the authority to settle via a consent order upon the respondent's payment of a civil penalty in the amount of $500. Any comments or questions on this case?
I have a question, just clarification. It sounds like they still haven't filed this return for 2020. Is that right?
So as a date of that report, they advised me that they had not filed their return yet. So both the complainant and respondent both state that there's a tax that's owed, but the return has yet to be filed. And what I told the complainant was you want to consult your closest tax professional and probably, have that situation dealt with. But as of right now, the return has yet to be filed.
Isn't it, other board members, when you're doing tax, you have a tax practice, and don't you typically send out a non-disclaimer saying you need to pay any tax that's owed as of this date, even though this extension is being filed? That's typical.
Yes, but usually when we file an extension, we make it clear that this is not an extension of time to pay. It is an extension of time to file.
Exactly.
Now, but there are times when you don't know, the client may not give you enough information. I will say this cryptocurrency, in 2020, the reporting requirements from the IRS were just starting to be pulled together. And what I got from clients, it was a disaster. It was the worst reporting that anybody could have, and then try to make heads or tails out of what your basis was and what you sold it for and what your gain is. So, and then compounded by the health of the spouse. But yeah, you always tell them this is an extension to file and not to pay.
But don't you think that was probably done? I mean,
So as the respondent told me, that's a normal part of their business to do that, but they can't recall in this instance whether they did it or not because it was such a tumultuous time for them.
okay, because it's usually paper. It's not like I remember. Oh, I remember that conversation.
And she
you know,
and there was no, they couldn't produce
they couldn't
anything.
produce it.
Okay. Well, probably the extension was filed electronically, and then you tell your client you need to make a payment of this amount, and they can either do that electronically or they send in a check. Now that there are times when maybe that second email doesn't get done, you get the return extended, but something happens, the emails, that just doesn't get sent. So that is possible.
Doesn't it sound like they hadn't determined how much the tax was going to be at that time?
Well,
I mean, I don't see how they could have filed a guess. They could have paid a guessed amount, but I don't think they did.
I mean, sometimes you go conservative and have them pay quite a bit more at the extension, and then sometimes the client says, I don't have any money, and just get me extended and we'll figure it out. So.
Or the issue too is the complainant didn't provide the required documents until a week before the deadline, and that puts the tax practitioner in a very tough situation.
Well, did the complainant contact the respondent in the period between May and October? Because if it had been my taxes, I would have been calling saying, okay, what do I owe? I need to go ahead and pay.
They did attempt contacts and couldn't get any, wasn't contacted back.
Other comments or questions? Is there a motion with respect to this case?
I just make a comment. I mean, I would lean on you, Gay, as the tax practitioner, and any of the rest of you who have done that. I mean, does this seem like a normal situation that you might encounter? I think we would all understand if you felt that way.
I can certainly see this happening. I don't understand why the return has not been filed yet. That's my only. But I also understand that sometimes clients are not helpful. And this cryptocurrency, again, you don't want to file a false return. And if the CPA doesn't feel like they've got accurate information or all of the information, they may be unable to prepare a return that is mostly correct,
And they don't want to put their name in it until they know.
Exactly.
Right.
Did
yeah,
they say?
I agree with every. Oh.
Please
I
go
agree
ahead,
with
Janet.
everything that. Okay, I agree with everything that Gay has said about the cryptocurrency filing and someone bringing in a return like that at the last minute. I could see how that could easily happen, and yes, typically the tax preparer would indicate the extension doesn't extend the time to pay, it just extends your time to file. So it is kind of typical, but, and I also agree that, not having filed it by now, that's not typical.
They went on their separate ways, obviously. So
I was going to,
So
apparently,
so in terms of the return being filed, I didn't really drill down on that because that was the complainant's business and not kind of part of it.
No, okay, yeah.
So
maybe
it's
they
not the
filed it
respondent's
now.
fault that it hasn't been filed.
No,
they
and that's
separate it
I think
from their
that's-
working relationship. Yeah.
But that also speaks to the proactiveness of the complainant, in my opinion. When you,
It does, yeah.
I mean,
yeah.
I'm almost inclined letter of warning and no fine.
Fully agree.
Well,
Something along those lines. Because Greg, to your point, giving it last minute, not doing anybody any favors. But we don't know. I mean, maybe the information doesn't come in until the last minute on crypto. I don't know. I don't know anything about it. So.
I feel like the preparer should have had a little more communication with the client, and because I'm constantly, June 15th, okay, remember you owe me this information or something. But I also know clients that just put it off and ignore and think it's going to go away. And
Well, and his wife was ill.
And his wife, yes.
Apparently. So,
Robert, are you willing to put your statement in the form of a motion?
I would like, yes, I move that we authorize a formal hearing with the authority to, a letter of warning only. Sorry, letter of warning only, no fine and no consent order, no hearing.
Do we have a motion?
Poorly worded, sorry.
On that?
Oh, it can be confusing, especially from that to the other thing. But yeah, just a letter. If you want to do that.
You know what I meant.
I second that.
Thank you. So we have a motion by Robert and a second by Gay to basically change the council proposed recommendation to simply issuing a letter of warning. Is there any further comment or discussion? Go ahead.
Just from my seat, there should have been a letter sent to them that some kind of documentation to the fact that estimating
Andy, your microphone has not been on.
now. Okay, I'm sorry. And I think there should have been something that should have been sent by the preparer, either that they had to have their tax return information in by a certain date, which is very common. That that if you're going to do an extension, that that we haven't had time to accumulate the information. Thus, what do you want to pay in based on your estimate because your information came too late. And then after the fact, it would seem like to me that the tax preparer would have jumped on it, asked for more information, and then come back to the point that, okay, hey, we have a problem here, but not take it all the way to the deadline of the of October or whenever the deadline was. And so I do think the preparer has has not represented the customer correctly, and thus should be responsible for some type of fine, as meaning that that we don't want other preparers around the state to say, well, if I don't want to do anything, well then I'll just get a letter of warning, because but that's just from my viewpoint from being in public practice for 28 years. We always did that.
Well, and I think you normally do. I guess I also considered that this licensee has been in the business since 1987 and has never had any other complaints, and probably had those safeguards in place, reminding that the clients, and they said that historically this client has always done it at the last minute, but they've always been able to get it done. I think this year was an extenuating year for them because of the spouse's illness, because of cryptocurrency issues, probably, and they may have also been dealing with PPP loans and everything else that came along with COVID. Things could have, more communication could have been there, but I just feel like they've demonstrated historically that they are trying to provide a good service, and I kind of hate to.
One thing I would ask
assess that
is,
hate to pick up when they're down.
Is it a single tax
Can you say that again, Janet?
Oh, sorry.
So I just said you kind of hate to kick them when they're down.
Yep.
Thank you, Janet. And then Miss Judy had a question.
I did. Sole proprietor. I mean, it's not like it's a big firm where they've got somebody reconciling. Okay, we filed an extension here, and we hadn't heard back from this list of people. We need to send them a letter and do this, especially with the spouses mitigating that whole medical situation. But also, do we know when the claimant and the respondent parted ways? Was it before? Do we know when? I mean, could it have been before the extension was out? Could it have been, or was it after this?
So the extension was filed in May of 21.
Yeah.
So this extension was done. It was subsequent after that, about October, November, where they parted ways.
Okay.
Where the complainant figured out that I have my taxes due.
Okay.
They didn't tell me I had this, and then that's when they parted ways.
Okay. So I was trying to figure out if it was prior to when they.
I do think how long they've been in practice without any history is a big factor, and I think if you were to move forward with a letter of warning, that is something that goes in their file, and so if they were to ever have an incident come up again, that's something that you would be it would appear on the report, and you could use that to further a higher penalty going forward if they were ever have another incident like this.
My comment, I just think this is small potatoes to be filing a complaint over too. I mean, $2,600 versus $4,000. Is there more to it than this?
That's it.
That's it?
Yep.
Right. So we have a motion and a second to recommend a letter of warning with respect to this matter. Is there any further comment or question? Karen, will you call the roll?
Kevin Monroe.
Aye.
Greg Gilbert.
Aye.
Gay Moon. Rob Vance.
Aye.
Thank you. That motion passes. And then I guess to council, given that is the committee's recommendation, I guess we should move this into the consent agenda for tomorrow's session. Next item is item number 15, case number 2023-001491. This, I think, involves the CPE case that Wendy was alluding to earlier. And here we have a respondent that was selected to have their 2020 and 2021 reporting period continuing professional education included in the CPE audit. They were notified of that audit on June 9 of 2022 and given a date of August 1, 2022 to provide proof of their CPE credit for the period. They submitted their response on August 30th, 2022. And after a review of the respondent's hours, the board found the respondent to be non-compliant with their CPE requirements. So the respondent was sent communication via both email and paper mail on August 30th, detailing their deficiency and the penalty hours they owed. At that time, the respondent was provided a due date of November 29 of 2022 to provide their CPE required hours, as well as the penalty hours they were assessed. When the respondent missed that November 29th due date, a final courtesy reminder was sent on December 6th in an attempt to communicate the overall 77.5 CPE hours that were required. The CPE hours owed by the respondent were not submitted and the complaint was opened. The respondent states they apologize for the lack of response. They've been attending as many CPE courses as possible in good faith and are on their way to fulfilling the requirements. The deficiencies initially identified were lack of proof of completing 80 overall hours of CPE, failing to earn 40 hours of technical subjects, and failing to earn at least 20 hours in 2021, and failing to complete at least the 2 credit hours in a board-approved TN state-specific course in 2020 and 2021. Also, initially, respondent provided proof of 34.5 hours, 29.5 of which were in 2020 and 5 in 2021. Respondent needed an additional 45.5 hours to become compliant and was assessed a 32-hour CPE penalty for failing to comply. During the investigation, the respondent explained that their spouse passed away in the fall of 2021 around the time of their licensure renewal period, and they were dealing with a lot of personal issues. They explained they became a single parent and had to move closer to other family and find a new job after moving. They did provide a spreadsheet detailing the CPE courses they had completed since April 6th. which indicated that 54.5 hours of CPE during 2022 and 23 towards their 2020 and 2021 requirements, and appears to be making progress towards completing the remaining 23 hours. Additionally, the respondents' application cycle stated that they had completed all required CPE hours and complied with all requirements. Based on a review of the respondent's firm name, website, and LinkedIn profile, the firm is using the accounting designation in violation of TCA 62-1-113. In this case, the recommendation is to authorize a formal. I'm sorry, I think I'm going to the wrong page here. Strike that last sentence. The respondent stating they had completed all mandatory CPE requirements when they had not, which violated Board Rule 0020-03-.041. Based on the aforementioned violations and mitigating factors, counsel recommends assessing a $1,000 civil penalty based on a $500 penalty for CPE violations under the code and a $500 penalty for the respondent's license renewal violations under board rule. So the recommendation is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $1,000. Additionally, counsel recommends requiring respondent to complete the outstanding 23 hours of continuing education for the 2020 and 2021 cycle within 30 days of execution of the consent order, and for the respondent to be included in the next continuing education audit. Comments or questions? Larry?
I have a couple of questions. Wendy, does this 23 hours include the penalty hours that were assessed?
Yes, it's
So they've done some of the penalty.
correct.
And then correct that this person signed their renewal application saying they had completed all the required hours when they really hadn't.
That's correct, yeah.
Is that right?
Yes.
Okay. So this is another case where I'm saying the penalty should be punitive enough. I mean, this penalty is less than what it would cost to do all the CPEs that they said they did, but they didn't do. You know, we want the licensees not to get put in a position where it's almost cheaper to not comply than it is to comply.
Don't they still have to do the hours? I mean, I agree. Anybody that signs
They
it
get caught.
saying
Only if they get caught.
only if they get caught. See, that's where I think we should audit more people. But
So you
That's a
didn't,
whole
you didn't
different
disallow any hours, right, that they reported. They just didn't do them, right? They just didn't do the
Yes.
hours.
Yeah,
Right.
correct.
They said they didn't. Okay.
and I mean, we've gotten a lot better with our 10% we're doing, but
So as
and
part
we're
of the
requiring them to list the courses, right? We got that far. And
At renewal,
Yeah, okay.
right.
Okay.
So as part of this penalty for, and I'm just asking, for dishonesty in doing the application,
Yes.
is that what the second 500's for?
Yes.
And that's where I'm saying, is that enough?
I'm totally open to a higher penalty and discussing that. I think that was something we just initially discussed as an initial recommendation, but I support a higher penalty if that's what the board feels or the committee feels.
On the committee.
That's why I didn't know to say the board or the committee, either one.
Still get a vote tomorrow on Larry.
Larry,
so.
you and I need to be quiet, I think.
No, we're still open to everyone's opinion. So
I think this is a very difficult situation for me. And I understand normally I would say the penalty should be increased. I think the spouse's death that occurred during that second reporting period, at least 2021, probably in some way, I guess I'm trying to play psychologist here. But
no, that's what we
entered
thought too.
into the bad decision
Yeah.
that was made.
That's what we were discussing and thinking too, and not to go back to earlier, but we didn't know how much we wanted to pile on either on top of that, so we're kind of leaving it at your discretion if you believe 500 is sufficient enough.
Well, he also became a single parent, and did you say did he had to move?
Yes, he moved and got a new position.
The spouse died, single parent, had to move, and he had changed jobs.
Correct.
Historically, they didn't. I mean, it was 10% of the renewals that we audited. People probably got by with a lot, and they didn't have to fill out any paper. Was that a year where they didn't have to fill out anything, or was that after we had required it?
This case is after our changes.
But in this particular case, it's not an issue. He didn't write fictitious hours or report fictitious hours that he never took. He just submitted what he had taken, and it wasn't enough. It didn't meet the requirements.
No, he stated 80 hours. He wrote on question 6, how many CPE credit hours did you earn in the 2-year reporting period? 80.
Was he listing his courses out as well?
Yeah, there should have been an attachment, and I can grab it if you don't have it.
Okay.
Okay.
I see. All right.
In addition, there are questions on the renewal, which you all are probably familiar with. Did you complete your 2 hours state-specific ethics? Did you complete your 20 hours in year 1? So you have to answer those questions. So in this situation, it's my understanding, for example, the ethics, he claimed he got the ethics but didn't.
Yeah, I understand. He circled yes.
Was he believing he had carryover from those prior years?
No.
Okay. All right.
So he typed yes, or I guess I don't know if you type it or if it's input option, but he put yes, 80, yes, so all these kind of questions.
Also, let me just rehash the process for you. So when we do the audit, there are many times there are deficiencies, and we give you time to make up those deficiencies. And so in this case, this individual was given time to make up the deficiencies and still didn't make up the deficiencies. I am total agreement and sympathy with all that he had been through. That was a year prior to us giving him the deadline to complete where he was deficient. Had he done that, this complaint never would have been opened. So we typically give folks 90 days to make up their deficiencies unless they ask for additional time. And then, and have reason, we'll give them some additional time.
But all those changes, a year's not very long.
I just wanted to make sure everybody knew that we didn't just open the complaint because, he didn't complete the CPE.
Any other comments?
Wendy, this is Jan. Wendy, did you say that he did have a list of CPE that wasn't completed?
So, Duke, correct me if I'm wrong, but he submitted a list, but it included CPE from the prior reporting period, so it was not the extent of the CPE that he would have needed to renew.
And did he say why he did that? Was he implying it was carryover, or he just accidentally picked it up?
I have a different theory, because if you count what 18 and 19 were to 20 and 21, you have 80. And it wasn't carryover. He didn't have any carryover. And so,
Lie about the dates.
he didn't.
But it sounds like you're saying that he reported as if he did have carryover.
Well, I guess I'm not a licensee, just recent licensee in this state, but carryover in my other state was a different situation where you had a running total of it. So the state was aware of it. There was no awareness of any carryover if they had any.
Out courses. So he picked out courses that indicated that they weren't carryover, but they just had different dates on it that added up to the 80.
So yeah, so it
No,
looked like to me.
he could have, if he, for some reason he thought I could use those, he may have then. So
He didn't dispute, but when it was brought up, when I interviewed him, he didn't dispute that he was behind and he didn't complete it. I mean, I had carryover, I had this, or I had that. He's like, yeah, I'm trying to get him done as fast as I can. Is what he told me when we talked.
Could it be possible that he didn't even have 80 for the previous section?
Possible.
think that comes back to the point that Larry's trying to make, is that
Yeah, it's honest.
what we have people who are responsible for getting continuing education, you know, the number one, why not make something up? Because I may not get caught. All right. In this case, he just attached a list. He had 80 hours. He didn't, you know, he didn't indicate, you know, we don't know if he actually reported or actually had 80 hours for the previous period. And then that is a whole lot cheaper to try to get by without having the 80 hours than going out and doing the courses. And I think that that's what we're kind of looking at as a board. Does that make sense? I mean, does it make sense to have such a small penalty associated with that? But I understand that he went through a lot. But he also signed the agreement that said that he did take 80 and that he took things that he didn't take, and so he made a conscious effort to trick the system. And then he had then he could have actually gone back and fixed it before it ever came to this level.
But I can excuse his not fixing it because of everything he was going through. The other is bad. I totally agree. I could see saying we would have fined him 1,000, but it's 500 because of his extenuating circumstance. I mean, I know what you're saying, Larry. It was a serious violation.
Well, he had the opportunity to ask for more time, and he didn't.
He had the opportunity to ask for more time. We also regularly advise candidates if they ask. You also have the option to go inactive while you sort through the difficulties you're having in your life, and then you can reactivate with your appropriate CPE. So there are avenues, but right now we have somebody actively licensed that also likely is not meeting the current renewal cycle requirements because he's so far behind on the prior period.
What I would offer up on this one is a motion that authorizes a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $1,500. Additionally, recommending requiring respondent to complete the outstanding 23 hours of continuing education for that 2020-21 cycle within 30 days of executing the consent order, and for the respondent to be included in the next continuing education audit. And my rationale is adding $500 to the element of the violation relating to reporting inappropriately. With that as a motion, is there a second?
I'll second.
We have a motion and a second. Any further discussion or comment?
Just a comment.
I'm just, sorry.
Go ahead.
Oh, I was just wondering, is the 30 days going to be enough to do 23 hours plus keep up with what needs to be done in the current reporting period?
I don't know that we really know that, although the 30-day clock starts ticking from when he executes the consent order. And so if he's really wanting to get back on track, I mean, I think he has a little bit of grace here to start going after it because he really needs to, or he's going to be out of position for this cycle as well.
So they have 30 days to sign the consent order from when it's sent to them. So let's say I sent it next
Really,
week.
he has a 60-day
He has
window.
30 days from that day that I send it to sign it.
And hopefully he's watching
Before it gets sent to a
today
hearing.
and tomorrow and knows what to do.
In addition, this isn't a surprise, meaning you're not adding additional hours that he was unaware of. He was advised in August of last year that these hours were due. So whether he's taken them or not, I don't know, but we're trying to.
He's had more time. Mm-hmm.
Andy, you had a comment?
I was just going to say, in situations like this, have we ever gone back to see what the previous period looked like?
Not that I recall.
I don't think so. I think we talked about that when we were implementing those new procedures, and I don't think you were on the board yet, Andy, but we felt like we were going to do a better job of, by having people in this situation, it would catch people. We would know whether they were being honest or not when they fill out the form, because they have to list the courses. And prior to that, they didn't even have to do that. And they could just say, oh, but bummer, I missed that one, or I didn't, I thought I did. But now, I mean, this particular case is a good example of where we can say, I mean, you listed stuff and it wasn't I mean, you didn't do it. So we're catching those kind of things.
We can certainly, between today and tomorrow, we might be able to pull what he submitted the prior renewal. I mean, he won't have an input to that, but we would have what he submitted for that renewal. That was the first cycle that we requested.
Okay.
That he submit. I mean, if that's relevant or of interest.
That might be relevant, just because that would not have the death of a spouse involved in it and those kind of things, right? I mean, those would be prior to those special circumstances.
I don't know if it's material or it matters, but the death of the spouse was at the end of 21.
Okay.
So it
I think
was.
you checked it, you're going to see it.
At month 22 of the.
I
Just to give
think
you perspective of when that happened.
Actually, on that, to me, the most relevant factor is that we're requiring him to be participating in the audit of the next cycle. I mean, he's already in violation. He knows it. We know it. He has the chance to make it right, he or she, and I'd say that to me is the most relevant thing that we can do here, rather than exhuming older periods here at this point.
Well, okay, how long are we required to keep our records? I mean, some of those records, 18, that may be expired for keeping.
So, right, I guess that's what I was saying, is we would only have what we have, not what the licensee has, or if there was a deficiency, they wouldn't be able to speak to it. So it's probably not wise to bring that into it without their ability to share their side of the story. I think we have enough to go on.
We do have a motion and a second. Is there any further discussion? Karen, will you call a roll? Aye.
Greg Gilbert.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye.
Thank you. The motion passes. The last item we have is item 16, which is a representation, case number 2022034-181. And here, the crux of this particular matter, the original recommendation relating to a complaint about using the term accounting on the part of the respondent's firm was to authorize a formal hearing with the authority to settle, requiring respondent to remove the term accountant or accounting from their firm name, website, and all other sites per our rules. The new development that's come up is that we have subsequently learned that the respondent had not received all of the previous information sent to them from prior counsel, because the respondent's name had been incorrectly marked down. And so there was a misconnect in terms of that not getting to the respondent. And so respondent contacted counsel and sought information. Once counsel sent respondent all the documents pertaining to the complaint, respondent contacted counsel and sought information on how to come into compliance. They've since provided counsel with evidence of a name change, specifically of them removing the word accounting from their name for their bank account, their LinkedIn page, and on their LLC registration with the Secretary of State. The respondent states that their website designer is in the process of reformatting the respondent's site to remove the word accounting from anywhere on that site, and that redesign was to be done no later than April 28th of 2023, and they will provide counsel proof of change. Respondent apologized for the mistake, and they were not aware of the restrictions, and that they will ensure that they remain in compliance going forward. Given that, counsel now recommends closing the complaint with a letter of warning, reminding the respondent of their responsibilities as it pertains to a title or designation. Go ahead.
They have sent me proof that they changed their
Okay,
website.
great.
Yeah, just wanted to confirm that.
Thank you. That was going to be one of my questions, so thank you, Taylor. So in this case, any questions or comments? If not, I move that we accept the new recommendation, which is to close the complaint with a letter of warning. I'll move that. Is there a second?
Second.
Thank you. We have a second. Any further discussion? Karen, will you call the roll?
Kevin Monroe.
Aye.
Greg Gilbert.
Aye.
Gay Moon.
Aye.
Rob Vance.
Aye. Motion passes. Mr. Chairman, that concludes the Enforcement Committee's reports, and I just want to say thanks for everyone's careful review, their questions and their comments. I think it helps us get to a fairer outcome. We had some complex and diverse cases today, so just appreciate everybody's patience and good thoughts and sharing their judgments and what they think is fair. So thank you.
Chairman, good job.
Mr. Chairman,
Yes.
I believe we missed a vote on number 9, which is the first one. I think maybe we thought we would lump a bunch of them together, but we missed the vote on number 9.
I apologize. So number 9 was the case that was moving into litigation monitoring. Let me get back to that. The recommendation there that we would be approving would be to place in litigation monitoring. This was the case regarding professional conduct that was in ongoing civil litigation. So I'll offer a motion to approve placing this in litigation monitoring. We have a second. Any further comment? Can you call the roll?
Kevin Monroe.
Aye.
Greg Gilbert.
Aye.
Gay Moon. Aye. Rob Vance.
Aye.
Motion passes. Thank you, and thank you for catching that, Wendy.
All righty. Thank you, Mr. Chairman. We will move on to the Executive Committee, and I will turn it over to our Executive Director, Wendy.
Mr. Chairman, item we have there is travel. We are finally picking up a little bit on travel. You'll notice on the travel report that I've included my travel and Duke's travel, but I've also included travel for Duke just coming to Nashville for his onboarding. He had a staff meeting and a town hall that all new employees were required to attend. So there's a few things there that would not be reoccurring. And, with Sherry being local, we didn't have travel necessarily for her regular day-to-day work. But I will be tracking this just because it's going to also help me with the budget so that we can make sure we capture that differently than we have in the past. So if there are any questions, happy to take any.
Are there any questions associated with travel? Okay.
Okay, so the next item on the agenda are the financials for the current fiscal year. So fiscal year 2023 ends in June, and your results that you have before you are for the month end February of 23. And so you have a total of, let's see, of revenue at $902,705. Total expenses at $655,245, which puts us on the plus side at $247,460 as of February. Of course, we've received most of our revenue because of renewals at this point, so we will slowly see that surplus drop as we finish out the fiscal year. So we've got 4 more months there. A few items that I will note throughout your specifics there. Of course, revenue is generally flat to the prior year, and we're looking fine according to budget. I did note that we have a little bit higher case revenue and a little bit lower licensing revenue, so the whole number is coming out flat, but we are seeing a little bit of decrease in licensing there. The next significant difference would be longevity. We are down 40% to the prior year, and that's due to a couple of things. With Sherry leaving, she was eligible for longevity anybody hired after 2015 no longer eligible for longevity. And then the way they did pay for performance this year shifted more of it to the raises rather than the bonus side of things. So that number is lower than it was in the prior year. You'll see travel is quite higher than it was the previous year. That's Take the Travel has resumed after COVID, so we're seeing more travel than we did in the prior year. In addition, NASBA's regional meeting for last summer in June, that expense went over to July, so it's actually falling in this fiscal year. So, and with the regional meetings, at least the Eastern being earlier this year, we are going to likely be over budget with regard to travel for the current year. Overall, though, I think we're going to be fine with some savings in some other areas. The other more significant item there is just the state professional services. We are seeing lower than the prior year, and of course we're favorable to budget there. I have noted that with additional consolidation in our office space, we are seeing a reduction in our rent of about $500 a month, so we'll save about $6,000 there over a 12-month period. So that is one of the reasons we're seeing that down 9% to the prior year. Year-end cost backs are up substantially to the prior year. A couple of reasons there. The main reason is that our legal fees year-to-date make up $54,000 of that increase over the prior year. And so we have seen in the past few months that number stabilizing, so getting back to a more normal level. But that is the major part of why we are seeing a higher number in cost backs. Overall,
Wendy, can I ask a question right there?
Sure.
You say that you say legal fees year to date make up $54,000 of the increase. So what are the numbers for the 2 years? Like if the $54,000 is the increase, what's the legal this year versus legal last year?
And see if I can get to it. I don't have it.
Is it like double or?
At the last meeting, it was almost triple, but we're not still triple. It's come more in line. I would say it's at least double. Yes.
So is that because more legal help was needed this year, or what?
I'm not sure. I did some inquiries about it and wasn't really able to get a solid answer. I think there may be a variety of factors. Sveta joined us in June last year, and she had some assistance from Taylor during the second half of last year trying to get up to speed on things. And so you've got salaries from both those individuals where once you have someone established, then your fees can be more stabilized. We also had a project in the fall where we had to review our rules and kind of make some determinations there internally for whether we expect changes maybe over the next year or two. And that was a project kind of out of the norm. So Sveta had to work on that. So and then we also have the salary increases, which were significant in legal. So we are going to see a higher number there than we have seen in the past.
Can we ask questions on other items?
Absolutely.
Okay. Let me kind of give you my conclusion of what I'm trying to do. What I'm trying to do is make it so that anyone on this board that wants to go to any NASBA events would somehow be able to do that within our budget. I'm wondering, are we hitting any of the costs for that to education or training or anything like that, where we could kind of pull some from?
So employee training, the line item for employee training, that is the registration fee.
That includes that.
For the NASBA events, correct.
All
so
right.
What falls under travel is the travel part.
Okay. And then in addition to that, for if Andy go. I'm not trying, I mean, I would like to just be able to allocate more money to it. But like if you travel, Andy, and you're on, you know, you're part of the NASBA board, does NASBA pay for your travel or does this board pay for it?
I have typically turned in my travel for airfare to NASBA.
Oh, good. Okay.
So for an annual meeting, I have to go there anyway because I'm on the board. So my airfare and the hotel up until the day Sunday is paid for by NASBA. Then Sunday through, you know, travel is not paid by the state.
Um, Well, I mean, I don't. What do we have to do to make it so that, I mean, because I know there were several. I haven't been in several years, and that's okay. I wanted everyone who's on this board that wanted to go and hadn't been to go. So I just stepped aside and said, "Okay, we got so many people going." But I think anybody that wants, not don't even think about me, but anybody that wants to go should be able to go because we need to be up to date on what's going on in the accounting world. I mean, we have enough surplus in our reserves. We have enough. Do we not have the wherewithal to allocate more toward those line items? Because we now have people who want to be more involved, in going to those events and are now more involved at NASBA than they used to be, and that sort of thing. I just want to know how we can accomplish that goal.
Each October is when we do the budgeting, and so we have historically budgeted for 5 individuals to attend the regional and then the annual meeting. You know, our statute gives us the authority to do that. However, that doesn't isn't in alignment with the department policy, which only allows 3 board members to attend.
Which is commerce, right?
Yeah.
Okay.
Yeah. And so we've kind of, I guess, landed on that 5 as in the past has been seems like a reasonable number, fits in the budget, gets most people the opportunity to attend one of the meetings each year. So we could certainly talk about it the next time we talk about the budget, or if there's a more immediate need to talk about it, we can, you know, amend that type of thing.
What's your feeling, Andy? I mean, you're our leader. I mean,
I understand where where we kind of get caught a little bit and where we can't take the whole board. I do know that when I was a Southeastern board of director that there's several boards in the Southeast that take their entire boards. You know, what's exciting for I think the Tennessee board is that we have so many people that are involved. And so it does show that people are reaching out and they're learning based on the committee that they're on. I also believe that, you know, that it really makes a strong statement when your entire board goes. But, you know, there are a lot of changes happening right now in our profession, number one. Number two, there's going to be a lot of changes, and there's going to be a lot of situations where this board's going to be asked to react. The beautiful thing about, you know, that what we voted on earlier today is that with Larry on the UAA committee, and you know, he really brought some vision to what happened and what went on, and so that really helps the board kind of understand more. You know, but at the same time, I can say that, you know, we have to be physically responsible, and so, you know, I kind of leave that up to our executive director and to the staff to say, you know, because I'm sure Tennessee can't afford for every board to go to every meeting on a national level. And so, you know, I think that where I kind of draw the line there is, you know, I'm just blessed to be able to serve and to go to some of these national meetings. And I don't want to see it, you know, us harm's way with
right. And I understand that, but we have got like $1.5 million in reserves. And I don't think that we're hurt. I mean, I know it's a big deal to get it through. Don't get me wrong. I'm not, trying to belittle that at all. But I do think if there's anything it should be, used for is basically the continuing education of this board to represent, this everything that we're trying to do. And I mean, I think we should. I don't know. I would recommend that we try to get more. I mean, I'm not talking about for this particular regional thing coming up or whatever. I'm talking about though where I mean, I was fortunate enough to be on a committee where it covered my cost, and anything it didn't cover, I covered. I didn't turn it into this board. And I want to see as many people as possible on this board. If they want to go, be able to go. I don't want us to have to turn down. How many did we turn down this time?
We had 9 people that wanted to attend the regionals this year.
Okay. I was one of those people, and I don't think I've been in a few years now. But, I think that anyone that is willing to take that time away from their own career and devote that time to learning what all the things being presented and discussed in those meetings, I think it's worth the investment from our budget, and we clearly have plenty of money to do it, to be able to do that. I mean, somebody's going to come in and get that money anyway at some point, and why not use it for our board to be better involved, more educated in the areas that things that are being presented there and whatnot. I believe in that. I'll go on. If I need to talk with somebody, I will, but I really think it's important. Even Duke, have you been to one of these, Duke?
He came to the executive director and legal conference.
Oh, okay, but that's not this.
But the investigator has not been to the regional or the annual in a long time,
and that's a big deal to me. I mean, and even our new
or attorneys,
legal,
any attorneys.
I mean,
right.
I couldn't think of a better use of the money that we have in our coffers than those things, in my opinion. And I don't know how it's going to get used, especially we're talking about this. Could we do a special use of any money that we get in case revenue that's coming up? I don't know. I mean, states and government authorities they're always doing special assessments. Can our board do one? To use the funds in a way we feel would be best to be used? So what do we have to do to make that happen? That's my question.
So this current fiscal year ends June 30. So I think after we get some realization as to what this fiscal year looks like, the July meeting will be talking about who's going to attend the annual meeting. We could talk about it then, and then plus at the time we talk about the budget for the following fiscal year. I think one of the things that's going to change our financial outlook is the salary adjustment schedule is going to be a significant impact on our bottom line going forward. And so we need to get a grasp on what that's going to look like. And so if a board, we can spend money, including our reserves, but if you run in the red 2 years in a row, then you go to a self-sufficiency hearing and explain to the legislature why and how you're going to handle it going forward, type thing. And that's not to say
we couldn't do that.
We couldn't do that. I'm just making sure that.
Yeah. I mean, I think but I don't think we're going to go. I mean, we're going to end up with more reserves probably this year to add to that $1.5 million.
We will. Yes.
Okay.
It'll be less than prior years.
Okay.
I believe.
Yeah. We've got a lot to, there's a big margin there for us to be able to go to. Okay.
Other discussion about the financials? Okay, committee, do I have a motion to present the financials or to approve the financials as presented?
So move.
The second?
Second.
All righty, roll call.
Andy Bonner,
Aye.
Larry Elmore,
Aye.
Greg Gilbert,
Aye.
Kevin Monroe.
Aye.
All right, we have come to the end of our day. What looked like a short lesson was a little longer than we thought.
Chairman, can I say one thing?
Yes, sir.
I want to brag on Duke. I think all of you saw how complicated and extensive these legal cases can be every time, or these investigative cases. And I was very impressed with the fact that the questions that we raised, he could answer. And even things that weren't in the report, he seemed to know a lot about the case itself when we were asking questions. And this is his first meeting. So I was very impressed. I just want to thank you for that. I think you did a great job.
Thank you very much. Appreciate it.
I agree with that, and I think also Taylor, in addition.
Yeah, I'm just saying this was his very
This
first.
is, I hold out hope for our new person.
Neil's gonna be great.
Neil,
He's
is that
ready
right?
to take
Neil?
over.
I didn't want to misspeak, but anyway, Neil.
Duke did a great job, and he's very helpful on this.
Yeah, I didn't mean to exclude you all. I was just saying,
No, it's not.
he's the new kid.
Yeah,
on the
yeah. No,
block.
he did do a great job though, and he was very helpful with beforehand as well.
I will say this, since I've been on the board, we have come a long way. A long way. You have no idea. You should go back and watch some videos. And I don't think, actually, Gay can appreciate that, and Larry, but from the get-go. Anyway, and Wendy, of course, and Karen, of course. So,
Any other comments? Seeing none, do I have a motion to adjourn? Second? All right, we'll see everybody at 8:30 in the morning. Thank you very much.